Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us. Salam sejahtera untuk kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan. Chief Justice of Constitutional Court of Indonesia, His Excellency Dr. Suhartoyo. First Chief Justice of Constitutional Court of Indonesia, His Excellency Professor Dr. Jimli Asidiki. Secretary General of Constitutional Court of Indonesia, Dr. Heru Setiawan. I would like to greet our distinguished speakers, President of Constitutional Court of Republic of Turkey, His Excellency Kadir Oskaya, Justice of Constitutional Court of Kingdom of Thailand, His Excellency Nopadon Tepitak, Justice of Constitutional Court of Republic of Azerbaijan, His Excellency Rauf Guliev, Justice of the Constitutional Court of Republic of Hungary, Her Excellency Professor Dr. Agnes Sine, Justice of Constitutional Court of Republic of Africa, South Africa, His Excellency Catherine Mary Savage, and Senior Consultant of Constitutional Court of Russian Federation, Mr. Nikita Igumnov. And also to all distinguished speakers whose manuscript has passed the reviewer selection, professors, scholars, experts, researchers, and ladies and gentlemen. Welcome to the 7th Indonesian Constitutional Court International Symposium. The 7th ICCIS, organized by the Constitutional Court of Republic Indonesia and as for 2025, is organized start from today to tomorrow, 8 to 9 October 2025, upon the theme Strengthening the Protection of Constitutional Rights through Constitutional Complaint. Our first agenda on opening session will be Indonesian National Anthem, Indonesia Raya. Please raise. Excellencies, ladies and gentlemen, now let's take a look on video profile of 7 ICCIS. the Republic of Indonesia proudly conduct the 7th Indonesian Constitutional Court International Symposium in Jakarta, 8 to 9 October 2025. This international academic forum gathers justices, academicians, researchers, experts, and practitioners from various countries to discuss a recent key topic in constitutional issues as it stands. It has also been previously held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019 and 2022, in Bandung 2021, and in Jakarta 2023. In 2025, there are 18 speakers who will enlighten our perspective upon the theme strengthening the protection of constitutional rights through constitutional complaint. For further detail, please visit www.iccis.nkri.id. Excellencies, ladies and gentlemen, now the next agenda is report from the Secretary General of Constitutional Court of Indonesia, followed by welcoming remarks from the Chief Justice of Constitutional Court of Indonesia. I would like to invite Dr. Heru Setiawan, followed by Chief Justice, His Excellency Dr. Suhartoyo, please.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, may peace and prosperity be upon us all. Om Swastiastu, Namo Buddhaya, Salam. His Excellency Dr. Suhartoyo, the Chief Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Professor Saldi Isra, the Deputy Chief Justice of the Constitutional Court of the Republic of Indonesia, Excellencies, Justices of the Constitutional Court of the Republic of Indonesia, distinguished Speaker and First Chief Justice of the Constitutional Court of the Republic of Indonesia, Professor Jimli Asidiki, also our esteemed speakers, His Excellency Mr. Kadir Oskaya, President of the Constitutional Court of the Republic of Turkey, His Excellency Mr. Nopodon Tepitak, Justice of the Constitutional Court of the Kingdom of Thailand, His Excellency Mr. Rauf Guliev, Justice of the Constitutional Court of the Republic of Azerbaijan, Her Excellency Professor Agnes Sin, Justice of the Constitutional Court of Hungary, Her Excellency Mr. Catherine Savage, Justice, the High Court of the Republic of South Africa, His Excellency Professor Idewa Gede Palguna, Professor at Udayana University and former Justice of the Constitutional Court of the Republic of Indonesia, the Honorable Mr. Nikita Igumnov, PhD, Senior Consultant of the Constitutional Court of the Russian Federation. We also extend our warmest welcome to all session chairs, respondents, and the selected paper presenters who will be contributing to the rich discourse over the next 2 days. Your Excellency, ladies and gentlemen, let us begin by offering our gratitude as we are gathered here today to convene the 7th Indonesian Constitutional Court International Symposium 2025. Since its establishment, the Constitutional Court of the Republic of Indonesia has been an active and respected participant in the global judicial community. Through its involvement in regional and international organizations, the Court has consistently contributed the promotion of constitutionalism, the rule of law, and the protection of fundamental rights. Beyond formal membership, the Court demonstrated its enduring commitment through various academic and capacity building initiatives. These include the publication of its international journal called Constitutional Review. The ICCIS itself stands as one of the Court's flagship academic programs. Since 2017 in Surakarta, the Symposium has been held in various cities in Indonesia, and today we convene the 7th edition. We continue this noble tradition. This year's theme, strengthening the protection of constitutional rights through constitutional complaint, bears immense strategic and contemporary relevance. In 2025, the Constitutional Court of Indonesia has been entrusted with a significant national mandate by the Ministry of National Development Planning Bappenas to prepare a policy paper on the constitutional complaint mechanism as a national priority program. This places ICCIS 2025 at the heart of a transformative moment, not only an academic forum, but also as a consultative platform for policy development at the highest level. We are pleased to report that the global legal community has responded with great enthusiasm. Through our call for paper, the Symposium received 51 manuscript submissions from various countries. Following a careful blind review process, 11 exceptional papers were selected for presentation in the upcoming session. To ensure broad accessibility and global reach, the Symposium is held virtually through the Zoom platform and streamed live via the Constitutional Court official YouTube channel. It is our hope that the Symposium will serve not only as a forum for academic exchange, but also as a catalyst for enduring collaboration and friendship among the global community of constitutional scholars and practitioners. That concludes my report. Thank you for your kind attention. It is now my honor to invite His Excellency Dr. Suhartoyo, Chief Justice, to deliver his welcoming remark and officially declare the opening of the 7th Indonesian Constitutional Court International Symposium 2025. Thank you. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh.
Baik, terima kasih. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, my peace and prosperity be upon us all. Om Swastiastu, Namo Buddhaya, greeting of Perdu. His Excellency Professor Saldi Isra, Deputy Chief Justice of the Constitutional Court of the Republic of Indonesia, Excellencies Constitutional Justice of the Republic of Indonesia, His Excellency Mr. Kadir Oskaya, President of the Constitutional Court of the Republic Turkey, His Excellency Mr. Nopadon Tepitek, Justice of the Constitutional Court of the Kingdom of Thailand, His Excellency Mr. Rauf Gulijeb, Justice of the Constitutional Court of the Republic of Azerbaijan, His Excellency Professor Dr. Agnes Sain, Justice of the Constitutional Court Hungary, His Excellency Ms. Catherine Sepitz, Justice of the High Court of the Republic of South Africa, His Excellency Professor Dr. Haji Jimli Asidiki as first Chief Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Professor Dr. Idewa Gede Palguna, former Justice of the Constitutional Court of the Republic of Indonesia, the Honorable Mr. Nikita Igumnov, PhD, Senior Consultant to the Constitutional Court of the Russian Federation, and the Honorable Mr. Heru Setiawan, Secretary General of the Constitutional Court of the Republic of Indonesia, institutional leaders, representatives, distinguished guests, distinguished colleagues, ladies and gentlemen. On behalf of the Constitutional Court of the Republic of Indonesia, I am honored and privileged to welcome you to the 7th Indonesian Constitutional Court Indonesia Symposium, ICCIS, held Jakarta and online. Them strengthening the protection of constitutional rights through constitutional compliance. This symposium continues the Constitutional Court's tradition of scholarly dialogue and comparative exchange established since the first ICCIS each year. We bring together judges, researchers, practitioners, and civil society representatives worldwide to reflect on pressing constitutional issues and share best practices that enrich our national and global constitutional discourse. The theme of constitutional compliance is significant for protecting citizens' constitutional rights. In various constitutional out worldwide, the constitutional compliance mechanism and developed in the essential instrument for ensuring the protection of different individual rights, while opening up wider access for the public to justice. This mechanism primarily protect from the public from the state's power and provide a platform for marginalized voice to be heard. Indonesia's discussion on the need to adopt a constitutional compliance mechanism and increasingly prevalent in various constitutional studies. Your Excellencies, the Chief Justice and Deputy Chief Justice, President on Foreign Constitutional Court, ladies and gentlemen. Through this symposium, we aim to deepen our collective understanding of constitutional compliance, particularly regarding their concept, including their role of protecting human rights, challenges, and potential implementation in Indonesia. The papers and discussions presented at this event will enrich academic literature and provide valuable insight for constitutional development. I sincerely thank all the speakers, contributors, and invited participants from Indonesia and abroad who have dedicated their time and expertise to this meeting. Your contributions reaffirm our shared commitment to advancing constitutionalism and the rule of law for the benefit of our citizens and the international community. May the symposium be inspiring and constructive for the development of the Constitutional Court worldwide. I hope you will actively discuss and exchange ideas in the coming days. I declare the 7th Indonesian Constitutional Court International Symposium officially open. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi 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 Om.
Thank you, Excellency and Secretary General. Ladies and gentlemen, please welcome our 18 speakers for 7th ICCIS on this video profile.
Please welcome our speakers of the 7th Indonesian Constitutional Court International Symposium. His Excellency, Professor Dr. Idewa Gede Palguna. His Excellency, Kadir Oskaya. His Excellency, Nopadon Tepitak. Her Excellency, Catherine Mary Savage. His Excellency, Ralph Guliev, Miss Sabina Mirsaeva, Miss Arzu Alieva. Her Excellency, Professor Dr. Agnes Chin. Mr. Nikita Igunov, PhD. Jane Natasha. Miss Rina Mumpuni Eurikinasi. Ramalina Ranaivo Mikea Manitra SH. Dr. Adia Paramita Prabandari. Tanto Lailam LLM. M. Reza Saputra SH. Thomas Sekumara. Murti Ayu Hapsari MH. Bimo Fajar Hantoro SH LLM. Fatima Azzahro MH. Tria Noviantika MH. Andia Musfira SHMH, Rilo Pamudi SMH, Dr. Sugeng MH, Dr. Ervina Fuadatul Hilmi, Fitri Maulidiah SH, Hikam Hulwanullah LLM, Torik Abdul Aziz Wibowo MH, Associate Professor Farah Ahmed.
Excellency, ladies and gentlemen, now I would like to invite our first Chief Justice of Constitutional Court of Indonesia to deliver keynote speech, Professor Dr. Jimli Asidiki.
Assalamualaikum warahmatullahi wabarakatuh. Good morning for everyone. I would like to express my thanks to the organizer, especially the Republic of Indonesia Constitutional Court that invited me to give a speech in this very important event. I congratulate the Constitutional Court to successfully again hold this 7th conference of ICCIS that could invite wide speakers from all countries to share opinion, to share the experience about the importance of the constitutional education to guarantee the constitutional rights of all the citizens of our respective countries prevail. I think this is a very good moment for us to share our experience, our knowledge, our views about Constitutional Court because the constitutions today prevail in every constitutional countries have many aspects of similarities. There is a trend of universalization of constitutional values around the world that we have to learn each other how to implement the idea of the constitutionality and constitutionalism in modern time. Indonesia, Alhamdulillah, after the reformations, we established Indonesian Constitutional Court in 2003, and up till now, it's already more than 20 years time, and we have so much experience, but still there are many we have to learn from other countries. So I would like to thanks very much to all the speakers and congratulate also to Chief Justice and Vice Chief Justice and also justices from all over friendly countries of Indonesia, that we really in need of talking together, learning each other, because although we have run our services to the country for more than 20 years, we still innovations which created around the world. So because of that, we have to learn each other. Even, for example, one of the topic we would like to discuss today is about constitutional complaint. Each countries of us have this different system and different experience about this, and many sometimes we have misunderstanding about what is actually constitutional. So very sorry, I just arrived at the Constitutional Court from my car because of traffic. So I would like to get permission from you all that I adjourn this speech for about 10 minutes. I'm going to go up to the room, conference room. Thank you very much. Matiin. Pak Heru. Bahasa Depok nih.
Kamera.
Assalamualaikum warahmatullahi wabarakatuh. Please apologize me for disturbing about 5 minutes because of my coming late. And now I am already in the place. I would like to continue about what I would like to say regarding the topic of the ICCIS conference today. In Indonesia, our constitutional system has a long experience starting from 1945 until now, 80 years already. And the development of our constitutional system and the court system is developing by the process of revising from time to time until the reform era in 1998, that we had 4 amendments of our original constitutions of 1945, and there in the new amended constitutions, we adopted the idea of constitutional court establishment in our legal system, and starting from that, the 5 cases can be ruled by the Constitutional Court. One is about the constitutional review of law as legislative acts. The second is about disputes of the result of general elections. And the third is about dispute related to conflict of authority between state institutions. And the fourth is the dissolutions of political parties. And the fifth is impeachment of the president and vice president. So we have 5 jurisdictions, while the Constitutional Court have limited power in the Constitution, and we have another apex of court system, that is Supreme Court, earlier developed since 1945, and all the ordinary cases filed and handled by the Supreme Court of the apex. There are 4 kinds of court system under the Supreme Court. One is general court, the second is religious court, the third is administrative court, and the other one is military court. As the general court and religious court, it is dealing with ordinary cases, while the administrative court is dealing with administrative decisions. Any administrative decisions or executive decisions may be filed as objects of litigations in the administrative court, and the PICS is on the Supreme Court. While if we can differentiate between this administrative court and constitutional court dealing with law, dealing with abstract norm, while administrative court is dealing with administrative, concrete, and individual norm. That is related to the issue of administrative decisions. And who can file a case to this court? To the Constitutional Court, there are 4 standing. One is individual citizens, even individual humankind, related to human right, and the individual citizen may file judicial review to the Constitutional Court, but it is limited only regarding law, legislative acts, while for the regulation under law, it should be filed to the Supreme Court directly. So we have not centralized model like in many countries. We had dual system of judicial review, one in the Supreme Court and the other one in the Constitutional Court. The Supreme Court dealing with two: judicial review regarding abstract norm of regulation under law, and the second, judicial review against administrative norm, administrative decisions. So this is what we have in Indonesia today regarding this constitutional and judicial review. But if we talk about the subjects, we differentiate between the issue of subjectum litis or subject of litigation and the objectum litis or the object of litigation. We can describe that actually what we understand about constitutional complaint, constitutional challenges, constitutional questions, it is already in the system applied in Indonesia now. Only the forum is different. Number one, if we start from the subjectum litis or the subjects of litigations, all the citizens of the Republic of Indonesia and even all humankind, although not citizens, but anybody have the human right according to the Indonesian Constitution may file a case against a law to the Constitutional Court. And this is actually part of the meaning of constitutional complaint. But it is related to the issue of the standing, the issue of subjectum litis. But when we talk about the objectum litis, the objects of litigation, then we divide between law and regulation under law. If it is regulation under law, so the file must go to the Supreme Court, while the constitutionality of law should be filed to the Constitutional Court. This is one case related to the meaning of constitutional complaint. And the second one, if we are dealing with concrete case like human right case, if a citizen considered his constitutional rights violated by the government, then they may go file a case against the government, against the authority through human right court. Human right court is special court under the general court, under the Supreme Court. So actually we have already that kind of constitutional complaint related to concrete case, not only dealing with abstract norm. But the problem is that it is differentiated between the Constitutional Court and the Supreme Court. If it is related to concrete issues, the citizen must go to the Supreme Court through Human Rights Court. So now the issue is how to centralize all the issue of a human right and human and constitutional right to the Constitutional Court. It may be one day, but of course it need to be another constitutional amendment. And the other issue is about constitutional questions. actually, constitutional questions, we can apply it now without any effort for constitutional amendment, because constitutional questions may be filed by an ordinary judge, proposed, for example, by parties in the criminal case in the ordinary court, and the judges may file constitutional review to the Constitutional Court. It only need judicial interpretations by the court. It does not need any constitutional amendment. But until now, this kind of issues of constitutional questions filed by a judge to the Constitutional Court related to the issue of the constitutionality of law is not yet applied by any judge in practice. So we have to socialize, to give awareness to all the court system, the ordinary court, to understand, comprehend betterly for the future, for the sake of constitutional guarantee of the constitutional rights of all the people. If any such cases happen in an ordinary court, so the ordinary court, the judge, may file a judicial review, a constitutional review against the law directly to the Constitutional Court. So this is only about the applications. Now, this is not yet any such case in Indonesian court system today. It means, ladies and gentlemen, I would like to describe that in Indonesian constitutional system today, the issue of constitutional complaint, constitutional question, constitutional individual challenge, individual complaint, and even constitutional questions, it's already there in legally by the rules, but not yet fully understood and be applied by any parties who thinks that their constitutional rights is violated by the government. So this is one of the issue that among countries of the Constitutional Court and also countries without Constitutional Court but having constitutional Supreme Court having their power, like in the United States of America, they don't have Constitutional Court, but the power of Constitutional Court done by the Supreme Court as what you call it, American models of constitutional adjudication. That's different from Indonesia. We have Chalcedonian model of constitutional court. So besides we have Supreme Court, we have also Constitutional Court. Thank you very much for your attentions, ladies and gentlemen. I hope we can share our ideas, experience to promote constitutionalism in the world, where today we have understood there is a bad trend, the quality of democracy around the world, the quality of rule of law around the world today experiencing from the problem of regressions. Even Indonesian democracy today becoming lower ranking than before. We are known as the third largest democracy in the world quantitatively, but our quality of democracy today in Indonesia this year 2025 has in the rank of 59 of the world. So this is, we need exchange of ideas to promote the quality and the integrity of our democratic and the rule of law system. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Excellency. Excellency, ladies and gentlemen, now we are taking break until 10:30 for the first session that will be chaired by Professor Susi Dwi Haryanti from University of Pajajaran. Excellency, ladies and gentlemen, welcome back. So I would like to invite our chair for session 1, Professor Susi Dwi Harjanti, to invite all the speakers. Please.
Thank you very much, Ibu Olvi. Good afternoon, everyone. It is my great pleasure to assist you as a chair of the first session of the 7th International Symposium that organized by the Indonesian Constitutional Court. Your Excellency, Constitutional Court Justices of the Republic of Indonesia, Honorable Justices of the Constitutional Courts from other countries, distinguished speakers, chairs, respondents, and other participants. Welcome to the first session of the 7th Indonesian Constitutional Court International Symposium with the big theme of strengthening the protection of constitutional rights through constitutional complaints. Now we are entering to the first session, and we have two speakers, or more than maybe, 2 or 3 speakers. And the first speakers will be High Excellency Mr. Nomadon Tapita, Justice of the Constitutional Court of the Kingdom of Thailand, which will become the respondent of his session is Mr. Saru Arifin of Universitas of Negeri Semarang, and Pak Helmi Kasim of the Constitutional Court. And then we have the second speaker, Professor Idewa Gedipalguna, with the respondent, Professor Diana Puspitawati from Universitas Brawijaya, then followed by Mr. Rizky Syabana Yulistia Putri, Mrs. Rizky Syabana Yulistia Putri from the Constitutional Court. And the third speaker will be Ibu Jane Natasha and Ibu Nisrina Mumpuni from Universitas of Erlangga. And the respondent will be Mr. Thomas Seku and Mr. Saiful Anwar. And now I'd like to invite the first speaker, His Excellency Mr. Nomadon Tapita, Justice of the Constitutional Court of the Kingdom of Thailand. You have around 50 minutes to present or to deliver your presentation. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Honorable Dr. Suhartoyo, Chief Justice of the Constitutional Court of the Republic of Indonesia. Professor Dr. Jimli Achidigi, First Chief Justice of the Constitutional Court of the Republic of Indonesia. Dr. Haru Satyarawan, Secretary General of the Constitutional Court of the Republic of Indonesia. Professor Susi Dwi Harjanti, distinguished participants, ladies and gentlemen. At the outset, let me, on behalf of the Constitutional Court of the Kingdom of Thailand, express our sincere thanks to the Constitutional Court of the Republic of Indonesia for inviting Thailand to participating in the 7th Indonesia Constitutional Court International Symposium. I'm very pleased to be able to share Thailand experience under the theme strengthening the protections of constitutional rights through constitutional complaints. So let me begin with an overview of Thailand's constitutional complaint system. Thailand places significant emphasis on the necessity of respecting and safeguarding the fundamental rights of Thai people. These rights are explicitly recognized in the Constitution, thereby ensuring clear and legally enforceable protections. Constitutional guarantees enable individuals to have confidence that their rights will be duly respected and that appropriate remedies will be available in the event of any infringement. The Constitutional Court of Thailand is still very young. We are only 28 years old since its inception in 1997. Nevertheless, the 1997 Constitution marked a major breakthrough in the protection of citizens' rights and liberties in a more concrete manner. It established the Constitutional Court and provided a mechanism whereby individuals who are parties to the case may petition the adjudicating court to refer the matter to the Constitutional Court for a more determination on whether a law contravenes the Constitution. However, under this framework, individuals were not permitted to submit petitions directly to the Constitutional Court. Under Section 212 of 2007 Constitution, our present Constitution, citizens were first given the right to challenge laws they believe violated their rights and freedoms. The complaint process required people to go through the National Human Rights Commission or the Ombudsman if those institutions did not forward the case. Individuals could then petition the jurisdictional court and ultimately the Constitutional Court. The object of a constitutional complaint was limited solely to the provisions of law. Later, Section 213 of the Constitution of the year 2017 expanded this safeguard. Now, Thai people can file petitions directly with the Constitutional Court if they believe a state agency or official has violated their rights or liberties. This was a major step in strengthening citizens' ability to protect their constitutional rights. That said, Section 213, in conjunction with Section 47 of the Organic Act on the Procedures of the Constitutional Court of the year 2018, sets out some exceptions. For example, the court cannot consider petitions relating to the following. First, general government policy decisions. Second, matters where the Constitution provides another specific process. Third, cases already in another court or with a final ruling. And fourth, certain judicial and military personnel matters. Apart from those exceptions, individuals can bring state actions for review directly. Furthermore, any provision of law that results in the infringement of the rights or liberties of the people may consider as an object of constitutional complaints. The Organic Act under Section 46 to 48 explains the procedures. Only a person directly affected can file, and usually the complaint must go first to the Ombudsman within 90 days. If the Ombudsman does not act within 60 days, the individuals can file directly with the court within 90 days again. The petition must be in writing, use respectful language, and include details such as the applicant's name, the facts of the case, the constitutional provisions relied upon, and the remedy requested. When a petition reaches the court, the process begins with the review of whether it complies with the rules. The court may assign at least 3 justices to examine the initially. Currently, the Constitutional Court operates with 2 benches of justices, each consisting of 4 members. Once the petition is accepted, the respondent is notified, and the court sets out the issues to be decided. For deliberation and ruling, the procedure is stricter. A bench of at least 7 justices must sit to decide the case. Importantly, every justice who rules the case must have participated in all essential proceedings. A justice who was absent from hearing on key issues cannot take part in the final ruling. This ensures consistency, fairness, and integrity in the court's judgments. The final ruling is issued in writing. Under Section 211 of the Constitution, the decision is binding on all state agencies, parliament, and the government. It must also be published in the Government Gazette within 30 days. The Organic Act, Section 47, allows the courts to attach enforcement measures. For instance, the court may specify that its decision only applies going forward, impose certain conditions, or assign a state agency or official to implement the ruling and report back within a set or a certain period. Let me share a few landmark rulings. First, ruling number 7/2563, or in the year 2020, titled The Right to Enter One's Own Country. This case concerned Mr. Witteveen Tibe Ulysses Michael, whose mother was Thai. The Ministry of Interior has banned him from entering Thailand under order number 115/2546. He petitioned the court under Section 213 on the grounds that his rights under Section 39 of the Constitution, which guarantees the right of a Thai national not to be expelled or barred, were violated. The court found that although he later received a Thai ID card and passport, making the individual grievance moot, the principle remained important for the public. Using its power under Section 51 of the Organic Act of the year 2018, the court proceeded to rule. It clarified that under Section 7 of the National Act of the year 1965, children of a Thai parent automatically acquire Thai nationality by birth, regardless of where they are born. Under Section 57 of the Immigration Act of the year 1997 and 79, Thai nationality can be proven with sufficient evidence through a process set by the Royal Thai Police Regulations. The court then noted that while regulations allow nationality proof, in practice, a ban on entry blocked individuals from exercising their right. Therefore, it ruled that a Thai national by birth cannot be deported or banned from entering Thailand. This strengthened the constitutional guarantee of nationality and clarified that administrative orders must respect constitutional rights. Example number 2, ruling number 15/2565, or in the year 2022, titled Judicial Appointments and Equality. This case involved the process of appointing judges of Supreme Administrative Court. Under Section 15 of the Act on Establishment of Administrative Court, the year 1999, the Judicial Commission of the Administrative Courts sends its candidate list to the Prime Minister, who then seeks approval from the Council of State before presenting it to the King for royal appointment. The petitioner argued that this process was inconsistent with the Constitution because judges from the Administrative Court had to pass through additional screening compared to judges from the Courts of Justice. The Constitutional Court ruled otherwise. The duties of administrative courts and courts of justice are different, so their appointment processes may differ without violating equality. The additional steps, approval by the Prime Minister and the respondent authority, was not discriminatory. It was aimed at ensuring ethical screening, not interfering with judicial independence. The Judicial Commission remained independent in selecting candidates, and the involvement of the Prime Minister did not undermine that independence. Therefore, the process was not contrary to Section 27 or the principle of equality, or Section 198, the independence of the judiciary of the Constitution. The ruling confirmed that procedural differences in judicial appointments are constitutional as long as they respect independence and fairness. I have one more example case, but due to time constraint, I just want to conclude it. To further ensure that rights and freedom of the Thai people are fully protected, the Office of the Constitutional Court, in collaboration with universities, conducted 2 studies on constitutional complaints under Section 213 in the year 2020 and 2024. The studies offered important recommendations as follows. First, they recommend the court must interpret the exception clauses of Section 47 on the Organic Act relating to the procedures of the court narrowly. This is to maximize protection of citizens' rights. In other words, the interpretation must allow people to exercise their rights as much as possible. Second, they recommended to revise Section 46 to 48 of the Organic Act to make procedures and deadlines clearer. Third, the studies help clarify the Ombudsman's role, either as an advisor who helps citizens file petitions or as a screener of petitions, while still allowing direct access to the court if a petition is rejected. Lastly, The study suggests that to improve public education so citizens know their constitutional rights and understand how to access the Constitutional Court. In conclusion, the constitutional complaints mechanism under Section 213 of the 2017 Constitution of Thailand is a vital tool. Combined with the strict procedures of the Constitutional Court, including careful review by panels of justices, it ensures that the rights and freedoms of the Thai people are effectively safeguarded. Thank you very much for your kind attention.
Thank you very much, His Excellency, Mr. Nomadon Tapitak, who already presented his thought in regard to the practice of the constitutional complaint in the Constitutional Court of Kingdom of Thailand. And now I invite two respondents, namely Mr. Saru Arifin, PhD of Universitas of Negeri Semarang, and Mr. Helmi Kasim of the Constitutional Court. Each of you could present your notes or your response to His Excellency Mr. Nomadon Tapitak presentation, and each of you have 5 minutes. Please, your turn, Mr. Saru Arifin.
Well, thank you so much, Professor Sui, for this time, and also His Excellency, Mr. Nomadon Tapitak. I apologize if I have spelled your name incorrectly. Yes, the Justice of the Constitutional Court of the Kingdom of Thailand.
Bagus.
Bagus, thank you. It was a great, insightful presentation. Your Constitutional Court head of us in terms of accommodating the constitutional complaint for your citizens. So from your presentation, and also I read your paper, I highlight two questions here and one additional question. That under Section 212/2007, citizens are not allowed to directly submit their complaint to the constitutional courts if their rights are found to be violated, but should first be presented to the National Human Rights Commission or Ombudsman or the relevant courts. However, under the Section 213/2017, it shifts into directly. Citizens can directly submit their complaint to the Constitutional Court, but a petition shall first be lodged with the Ombudsman within 90 days of knowledge or presumed knowledge of the infringement of right or liberty. So it is clearly said that there are two channels or mechanisms of complaint for the citizen of Thailand for defending funds violated. So my question first, what are the reasons why there are two channels, direct and indirect, for citizens to bring complaints to the Constitutional Court? And the second one, under what circumstances did the Human Rights Commission or Ombudsman fail to submit a citizen's complaint to the Constitutional Courts? These two questions are critical for us in Indonesia, as on the way to establish such a kind of constitutional complaint for maybe for the future constitutional amendment. And the additional question is, how does the Constitutional Court collaborate, particularly with the universities there? Thank you. That are three questions from me as your discussion today, and thank you very much for your response.
Thank you, Mr. Saru Arifin, PhD. And now I'll move to another respondent.
Thank you, Prof. Susi.
He replaced by Dr. Mary Christian Putri. Please, Dr. Mary, your turn now.
Thank you so much. Good morning, distinguished justices, honorable colleagues, and esteemed participants. Well, it is a privilege to offer this commentary as part of this ICCIS. First of all, I would like to extend my sincere appreciations to the Constitutional Court of Thailand for the very comprehensive and enlightening presentations on the evolutions of the constitutional complaint system under your 2017 constitution. As I read in your paper, well, the Thai Constitutional Court provides a very thorough and thoughtful overview of the development of its constitutional complaint mechanism, especially when we trace its evolutions from 2007, firstly under Section 212, to the expanded rights that is enshrined under Sections 213 of the 2017 Constitution. Well, the framework as described reveals a very clear intent to balance the accessibility for citizens with rigorous procedural and judicial independence. From the identifications of challenges, such as procedural barriers through the ombudsmans and the need for greater public awareness, it reflects a commendable spirit of self-assessment. I can say the recommendations for reform would include the redefinitions of ombudsman role that can improve citizen access and also resonate strongly with broader trends in constitutional practice that aim the deepening democratic accountability and transparency. In particular, the proposal to allow more direct filing of constitutional complaints in urgent cases that aligns with the modern principle of, we can say, effective constitutional protections, that rights must not only exist formally, but also should be enforceable in practice. Well, furthermore, the call for enhanced public education on constitutional rights would emphasize the court's recognition that justice is not solely the outcomes of judicial proceedings, but also civic understanding and its participation itself. Well, I don't want or I would not like to address questions, but only give comment here. In conclusion, overall, I can say that Thailand Constitutional Court's experience has offered very valuable insights into how constitutional complaint mechanism can evolve to balance efficiency, accessibility, and also independence. Of course, continued refinement of procedural mechanism, especially in relation to the ombudsman gatekeeping, and also the clarity of filing procedures would further strengthen the system. Well, because the paper already presents a comprehensive and transparent overview of Thailand's evolving constitutional complaint mechanism, it also reflects an ongoing institutional effort to balance the individual rights and judicial efficiency. Future reforms, especially as I mentioned regarding ombudsman function and broader citizen engagement, hopefully would significantly enhance the constitutional justice accessibility itself and the democratic accountability. I think that's all from me. Thank you so much for the opportunity. Thank you.
Thank you, Ibu Dr. Mary Christian Putri. Actually, our first speaker that followed by respondent will be finished at 11. But I'd like to invite some of the questions. If any question that you want to raise to His Excellency, Mr. Nopadon Tepik. Any question or any response? In addition to Pak Dr. Sarul Arifin and Ibu Dr. Mary Christian. Okay, if there is no question, then now, thank you again, His Excellency Sernopadon Tapita and Bapak Dr. Saru Arifin and Ibu Dr. Mary Christian for your presentation and also for your response. Okay, do you want to say something?
Yes, I think I have a question from Dr. Saru Arifin. So I'd like to reply or react to his question raised. His question is concerning about the two channels of, the petitions to the Constitutional Court, and he wonder why it happened. I would say that at the inception of, the founding of the Constitutional Court in the year 2007, we at that time we don't see any much channel, so we let the people or the public who feel that their rights and liberties were violated can file their complaints to that independent organs, that is Human Rights Commission. But later on, we found that maybe only one channel or that independent organ may not be enough to receive the complaint or to accept the case. So we found another channel, that is the ombudsman and others. And your second question is about what happened if they fail or those organs fail to further submit to the court. It's reflected clearly in the Constitution that in case the ombudsman or other independent organs drop the case or don't even react within 90 days, people can directly submit the case to the court, and the court has to accept the case and consider and rule it, whether we accept the case or we rule it out. And your third question, how we collaborate with universities. This is another advanced step of the Constitutional Court, that we want to educate people to know more about the Constitution. That's why we have signed some memorandum of understanding with various universities to do some research, that how we can get involved and get people more educated to know their rights and liberties and how to defend their rights and liberty through the Constitutional Court. I hope this can clarify the question raised by Dr. Saru Arifin. And I also would like to thank Mary Christian Putri for your kind comment and observations. I already take note of your comment, and we'll try to do our best and do as you recommend. Thank you very much.
Thank you, His Excellency, Mr. Tapita, to your response to Pak Saru Arifin, also your regards to Ibu Dr. Mary Christian. And now we already finished with our first speaker, and move. Thank you again. And now I invite the second speaker, Professor Idewa Palguna.
Okay. Good morning, everyone. Or it's already afternoon. Sorry. Thank you very much, Prof. Susi, and all our distinguished speakers and participants of this international symposium. It is really an honor for me to be invited, maybe for the fourth or the fifth times for the symposium. Yes, I would like to present my presentation as short as possible and as positive and as effective as possible. I give a title to my presentation: revisiting the idea of adopting constitutional complaint for Indonesia. Let me first quote a sentence, an important sentence from Thomas Paine, what is an independent warrior in the in the process of independence of the United States of America. He says, a constitution is not a thing in name only, but in fact, it has not an ideal, but a real existence. And wherever it cannot be produced in a visible form, there is none. That's why this quotation is important to me, because it's so closely related to the topic, which is constitutional complaint. Let me first present a brief introduction to my presentation. I intentionally use the word revisiting in this presentation because it is derived from the fact that I have been promoting the idea of adopting the constitutional complaint in many occasions since 2009. Even my PhD dissertation myself at the University of Indonesia in 2011 was precisely about the issue of constitutional complaint. As we know, what is constitutional complaint? It is generally understood as a complaint lodged before court, here particularly constitutional court, by individual citizen who claims that the state official's act or omission had infringed his or her constitutional rights, while all available legal remedies had been exhausted, or there is no available legal remedy at all. That's a general understanding or definition of constitutional complaint. And we know the Indonesian Constitutional Court has no constitutional power or constitutional authority to adjudicate cases of constitutional complaint. If we look at the Article 24C, especially paragraph 1 of the Indonesian Constitution of 1945, it strictly delimits the court's constitutional powers to review, firstly, to review the constitutionality of law, or commonly popularly known as judicial review cases. Secondly, to decide disputes of authorities among state institutions whose authorities are given by the Constitution. Thirdly, to decide dissolution of political party. And fourthly, to decide dispute of general election results, including the election of regional elections now, whether for the scope of mayoralty or regency and the scope of province. Now, that's the fact we are facing. Meanwhile, in Article 24C, paragraph 2, describes that the Constitutional Court is obliged to give decision on the opinion of the House of Representatives that the President and or Vice President had committed certain act or acts described in the Constitution and or no longer meets the qualification as President and or Vice President. So actually, there are 5 constitutional powers within the Constitutional Court of the Republic of Indonesia. Now, so what is the legal issue? Of course, the court's lack of power to adjudicate cases of constitutional complaint has left violations of citizen constitutional right caused by acts or by omissions of public officials remain unsolved. Here, then, an intriguing question arises. is there any possibility, at least theoretically, to adopt constitutional complaint mechanism without formally amending the constitution? Why I set aside the formal amendment? Because it is maybe for the time being, it is politically, maybe it is ideally desirable, but I think politically impossible, at least for the time being. So I would like to emphasize the other way of theoretically, maybe we can find another way to introduce constitutional complaint or to adopt constitutional complaint mechanism within our legal system without formally amending the constitution. And the my hypothetical thesis, yes, there is. Here is the explanation. We know that theoretically speaking, at least according to an expert, an Austrian leading expert, Herbert Hausmaninger, just to name a relevant reference, the core idea behind the birth or the establishment of constitutional court is the idea of constitutional review. Meanwhile, the constitutional review itself is the product of modern system of government based on rule of law, separation of powers, and protection of human rights. There are two main tasks of constitutional review, according to Hausmaninger. First, to safeguard the functioning of democratic processes within the framework of mutual influence relation among legislative, executive, and the judiciary state powers. Secondly, to protect the rights and life of citizens from violations conducted by any branch of state powers. So we can say that, in other words, the main purposes of establishing constitutional court, wherever it is, of course, including in Indonesia, is to uphold the principles of rule of law and to give maximum protection to fundamental rights. So constitutional complaint is a form of legal remedy that realizes the idea of giving protection to fundamental rights of especially of citizens. Hence, or accordingly, theoretically speaking, the power to adjudicate constitutional complaint case is inherent in the court's constitutional power. So if we analyze further, by nature, constitutional review of law and constitutional complaint are both, according to my opinion, are both in the same domain. That is, the domain of constitutional review. The only difference between the two is the object to be reviewed. Is the object to be reviewed by both mechanisms. In constitutional review of law case, the object to be reviewed is the constitutionality of law's norms, while in the case of constitutional complaint, the object to be reviewed is the constitutionality of act or omission of public officials. Accordingly, if constitutional complaint mechanism is intended to be adopted in Indonesia without conducting formal amendment to the constitution, it can be achieved by doing a small revision in the current law on constitutional court by way that the lawmaker may widen the scope of constitutional review of law so as to include constitutional complaint. That's the first way. The second possible way of adopting constitutional complaint mechanism is through judicial interpretation. in case made by the court, the constitutional court, as long as the case or the issue here, the Public Officials Act or omission, can be attributed to certain law, for it must be submitted as the constitutional review of law case. Here, the Constitutional Court may rule that the law itself is constitutional, but public official or public officials relevant to the issue has been wrongly interpreted the law in such a way that infringe some citizen constitutional right or rights, or the public official has committed some negligence in relation with the law concerned, with the law to be reviewed, which resulted in the infringement of some citizens' constitutional right. So, despite the petition was lodged in the form of judicial review of law, but according to my opinion, the court may give its considerations and its ruling that, well, the law itself is constitutional, but the interpretation of official in applying that law is unconstitutional, so as to create violations to the citizens' constitutional rights. I think that is my short presentations. I would like to give chance to the all participants of the symposium, especially the respondents, to give to my short presentation. Thank you, Prof. Susi. Time is yours.
Thank you, Professor Palguna, for your presentation. And now we have two respondents in response to Professor Palguna thought or presentation. We have Professor Diana Puspitawati from Universitas Brawijaya, as well as we have Ibu Rizky Sabana Yulistia Putri from Constitutional Court. The first time I will give to Professor Puspitawati. Please.
Thank you. Good morning, all, and how it's nice to see all of you all do in online meeting. And how are you, Prof. Palguna? Long time no see. Hope everything all well with you. So first of all, I would like to express my appreciation to Prof. Palguna for his insightful and well-structured presentation about the possibility of introducing or revisiting the constitutional complaint mechanism in Indonesia with clarity, philosophical depth, and maybe if this paper is will be continued, maybe there is a comparative awareness of the paper. As I can see, the strength of the presentation are clear and compelling. Prof. Palguna successfully emphasizing that constitutional government must exist to protect the individual rights. So without this, the constitutional right can be stated as violated. Just give me a sec. Okay, Prof. Palguna approach also reflect a strong understanding that rights without remedies remain aspirational, and the Indonesian constitutional justice system needs to evolve from abstract norm to control the concrete rights of protection. However, there is maybe, I would not say gap, but there is maybe there is the matter that warrant the further discussion. The first is, while there is no need to amend constitution in a constitutional complaint, as you said, maybe it would be beneficial if we can explore more deeply on how the mechanism would be designed institutionally. I mean, adapting is one thing, but implementation design is another. I mean, maybe how about the jurisdictional boundaries, the admissibility rules, and avoidance of overlap with Supreme Court? And the second is what safeguards are needed to ensure the constitutional complaint improve access to justice without turning the constitutional court into a general appeals body, maybe. So thirdly it would be benefit from outlining possible maybe hybrid or limited model. I mean, is that possibility? Is it? I mean, if integrated is it's out of context, I think. So a hybrid and limited model, is it? Do you think it is suitable for the model of constitutional complaint system? And how about the judicial workload and accessibility that deserve attention to ensure that the constitutional court remains effective and not overwhelmed? So to sum up, I think Prof. Palguna presentation makes a timely and important contribution to Indonesian constitutional discourse. It invites us to think beyond the textual guarantees of right toward the effective constitutional remedies. My suggestion in maybe it can be we can all think that we can move from why to how by articulating the concrete model and transition that would make a constitutional complaint mechanism both feasible and sustainable for Indonesian context. I think that's what I can say. I'm sorry if there is a mistake in my response to the presentation. Thank you, Prof. Susi.
Thank you, Prof. Diana. And now we move to Ibu Rizky Syabana Yulistia Putri. Your time is now.
Thank you, Prof. Susi, and Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone, and especially good afternoon for His Excellency, former Justice Pak Palguna. Honestly, I'm a bit nervous right now because, yeah, it's just an honor for me to be given this opportunity as a respondent for His Excellency Pak Palguna. Thank you for this opportunity. And Pak Palguna, thank you for your kindness to always willingly share your knowledge to us. And I think I don't have any capacity or capability to give any comment for Pak Palguna presentation. I believe that Pak Palguna is such an expert in constitutional complaint. And just like usual, I always admire you, Pak Palguna. I read Pak Palguna's book about constitutional complaints, and it's given me so many insights and broadened my knowledge about constitutional complaint. And now hearing Pak Palguna presentation live, just like now, helped me better to understand the key points of constitutional complaints and its urgency for a better Indonesian constitutional rights protection. His Excellency, former Justice Pak Palguna, if you don't mind, I have one question based on your presentation. And if I'm not mistaken, you explained that if constitutional complaints mechanism is intended to be adopted in Indonesia, there are three methods. The first one is conducting formal amendment of constitution. The second one, by doing small revision in constitutional court, in law of constitutional court. And the third, by adopting constitutional complaint mechanism through judicial interpretation. Within the three methods, which one is the best method to be implemented in Indonesia today? And is there any urgency to immediately implement constitutional complaints in Indonesia? And I think it's not one yet. I have one question more. And if constitutional complaints are indeed established as one of the authorities of constitutional court in Indonesia, is there any impact on the relation between our state institution, like Constitutional Court and the Supreme Court, or between the Constitutional Court and the Judicial Commission, or with the House of Representatives? I think that's all. Thank you, Pak Palguna, for your presentation. Thank you, Prof. Susi, for the opportunity. Have a good day, everyone. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Ibu Rizkia Sabana. And now, Professor Palguna, you have some question that raised by Professor Puspitawati and Ibu Rizkia Sabana. Maybe, if I'm not mistaken, there are around 4 questions question raised by Professor Puspitawati. Not 4, and the rest 2 questions raised by by Ibu Rizky Shabana. Please, Professor Palguna.
Okay, thank you, Prof. Susi, and thank you, Professor Diana. The last time we met is in the dojo at the Constitutional Court.
Yes, and I doubted that we can do it again. Concerning the age of us.
Oh yeah. Of
Sudah
course,
gak
of
kuat
course.
kali, Prof ya.
Yeah, of course, but it doesn't matter. When we are doing Aikido, we need no power at all. Okay. About your question, how the mechanism should be designed and implemented. The idea I presented in my presentations, how the mechanism should be designed and implement in the real world in Indonesia today. Okay. In my opinion, in my imaginations, it could be implemented by doing a small revision in our constitutional court law, the law on constitutional court, especially in the law procedure when the court doing its authority to review the constitutionality of law. I mean, the lawmakers, President and the House of Representatives, make a small revision as to the meaning of judicial review or constitutional review by extending the scope of the term so as to include constitutional complaint. It means that a complaint may be lodged by a complainant, here is citizens of the Republic of Indonesia, that an act or omission conducted by state officials derived from a certain law has been, the petition should, may be submitted in the form of constitutional review case, but what is called the claim is not or the demand is not to ask for the court to say or to rule that some norm of the law constitutional, but to rule that state official acts or omissions derived from, but the state official acts or omission that deemed to have infringed the constitutional right of the concern is derived from a wrongly interpreted norm of the law to be reviewed in the case, in the concerned case. That's what is theoretically called official or official interpretation by the lawmakers, or extended interpretation made by the lawmakers. So it doesn't need to make a formal amendment to our constitution, but by small revision in our constitutional court law by extending the scope of the constitution, the scope of the case, the term of constitutionality of law case or constitutionality of law petition, so as to include the constitutional complaint substance. So the court may decide that, okay, the law is constitutional, but the public official has been wrongly interpreted the norm of the law so as to result in the violations of the citizens' concern, the citizen constitutional rights concern. That is the first possibilities, in my opinion. And secondly, how to avoid, if I'm not mistaken, your second question is how to avoid maybe workloads. Yeah. I think the work, to avoid the workloads can be anticipated by detailing the law of procedures of the Constitutional Court when the court doing its constitutional power. By, for example, it is not all the case of constitutional complaint maybe reach the what is called reach the full bench court, the court full bench, but maybe from if we take Germany for example, since the very beginning of the case, the court officials in the front desk can have the power to select which one is the case of constitutional complaint, which one is only a kind of what is called in Bahasa Indonesia surat kaleng, or only an ordinary complaint, because there is not include constitutional rights violations. That's the first, maybe the first method. The second step could be that at first, the complaint directed to the court maybe can be handled by only one single judge, but the decision but the decisions of the case must be done by all the 9 justices. So the case of workloads, I think, can be reduced significantly by that mechanism. What is the third question, Prof. Susi? I lost my concentration. Is there another question left from Prof. Diana?
No, I think it has been included in your
Okay.
writing. I think it's okay.
Well, thank you. Now,
Professor Diana say that move to how to paradigm, move to why constitutional complaint, then to make it implemented, then how. Okay. Move from why to how. Okay. Yeah. And now you can move to the question that raised by Ibu Rizky Syabari.
Yeah. Okay, thank you, Rizky. Yeah, thank you for reading my book, as you said. And now I would like to give a response to your interesting question. As I said in my presentations, of course, there are 3 ways to that can be there are 3 ways that can be used if we want to adopt constitutional complaint in our legal system. The first is formal amendment. Secondly, by revising our constitutional court law or law on constitutional court, and thirdly, by the judicial interpretations. That is the role of the constitutional court itself. So could be so prominent in the last mechanism. So if you ask me which one is the best, and the term best I understood as the most appropriate way for the time being, I think is doing a small revision to our constitutional court law is our best choice for the time being. Why? Because it is politically possible, but it depends on how the society, especially civil society, NGOs, and academicians, giving pressure to the lawmakers, so as to make there is no choice but to accept the idea of adopting the constitutional complaint mechanisms without amending, without the need for amending formally the constitutions of 1945. As I said, by widening or by extending the scope of the meaning of judicial review mechanism, so as to include constitutional complaint substances inside it. That's the first and response of my presentation or your question. The second question, is there any possible impact in relation with other institutions? Of course, yeah, of course, there could be impacts in relation with other institutions, especially with the Supreme Court. But I would like to emphasize here that, again, when compared to the practice applied in Germany, that why there is no complications, quote unquote, between the Bundesverfassungsgericht or the Federal Constitutional Court of Germany and the Bundesgerichtshof or the Supreme Court of Germany for ordinary terms, or the Mahkamah Agung untuk urusan peradilan umum in bahasa Indonesia, is by strictly emphasizing that the Constitutional Court would not replace the authority of the Supreme Court, but only will focusing on question whether a state official's act or omission has any possibility or has any connections with the violations of citizen constitutional right because of their misinterpretation to revision. I mean, to a norm of a law, or just only because their negligence in applying a law. So we would not, the Constitutional Court would not, what is called, and a kind of encroach the authority of the Supreme Court, but only will give attention to whether there is a violation of citizen constitutional rights. In short, it's like that. Not to take over the power of the Supreme Court. And I think that possibility could be explained in in a good way, in an appropriate way, when we already make our revision in the law procedure of the Constitutional Court, when the court doing its constitutional power or constitutional authority. I think that's what all what I can say to respond to what Rizky Sabana asked me for. Thank you, Prof. Susi.
Thank you, Professor Palguna, for your response and your answer to those questions that raised by Professor Diana and Ibu Rizky Shobana. And now I think we have to approach the final time for the second speaker, because there's only a quarter to 12, and we still have the third speaker, that is Ibu Jane Natasha and Ibu Nisrina Mumpuni from Universitas Erlangga, and who become respondent is Bapak Tomaseku Marah and Bapak Saiful Anwar. Again, say thank you to Professor Palguna, Professor Diana, and Ibu Rizky Shobana.
Okay, thank you.
Okay, so distinguished participant, and now we are entering the third speaker. There are two young speakers with us now, Ibu Natasha and Ibu Nisrina Mumpuni Euriki, both of them from Universitas Erlangga, and you have 15 minutes maximum to present your thought. Then afterwards, followed by a response from two respondents. As I mentioned before, Pak Tomaseku Marah and Pak Saiful Anwar. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya, best blessing for all of us. Good afternoon, everyone. It is truly an honor for us to be selected as one of the presenters of the 7th Indonesian Constitutional Court International Symposium. Before we begin with our presentation, let me introduce ourselves. My name is Nisrina Mumpuni Yurikinasi, along with my friend here, Jane Natasha. Today's presentation, we will be presenting our paper with the title, Urgency of Introducing Constitutional Complaint in Indonesia for the Reconstruction of Human Rights Protection under the 1945 Constitution. So this is us. We basically from the same university. So this is the contents of our paper. We will be starting with background, two headings, and end up with closing as well. The 1945 Constitution basically already regulated our human rights as a citizen of Indonesia, but it is still lacking their practical due to the limited of constitutional court jurisdiction for only judicial review. The issue individual rights is often rising from the violation of this limitation. For example, the court decision itself. Therefore, constitutional complaint creates a legal vacuum and as a major need to ensure the protection of human rights in Indonesia. Now, turning to our first heading. First, we have to enlighten ourselves. What is the concept of constitutional rights under the 1945 Constitution? As I mentioned before, the 1945 Constitution has regulated several rights for their citizens, especially the constitutional rights. In general, constitutional rights in Indonesia is followed by the identity as a negara hukum, or constitutional state, as explicitly stated in Article 1, Paragraph 3 of the 1945 Constitution. Then, following the new order regime, Indonesia adopting a form of Bill of Rights, which introduced Article 28 to Article 20J that regulates a strong protection of human rights for all Indonesian citizens. Therefore, there are four characteristics of constitutional rights. One, constitutional rights is a fundamental rights because it is written in Constitution, which serves as the nation's fundamental law. Second, constitutional right must be respected by all branches of government, including legislative, executive, and judicial. Third, any action by a state that contradicts of these human rights must be declared null and void by the court. Fourth, the protection afforded by the Constitution to these rights is especially against actions or violation by the states. Now we have to understand the concept of constitutional complaint. Constitutional complaint is a fundamental legal mechanism designed to provide direct protection for an individual's constitutional rights. This also means as a legal remedy to any individual legal entity who believes that their constitutional rights, as guaranteed by the Constitution, have been violated by an act or omission of a public authority. The primary objective of a constitutional complaint is to provide legal certainty and a guarantee for the protection of citizens' constitutional rights, which constitute the core content of any constitution. Then what is the necessity of human rights section in the 1945 Constitution followed by constitutional complaint? As we already know, the Constitutional Court's authority, as restrictively outlined in the 1945 Constitution, is limited to judicial review of legislation, jurisdiction of disputes between state institutions, resolution of political parties, and election result disputes. There is no explicit mechanism to challenge specific decisions, policies, or action of public authorities that potentially violates upon the fundamental rights guaranteed by the 1945 Constitution. Therefore, formally institutionalizing the constitutional complaint is not about just creating a new demand, but about providing a proper, efficient, and honest procedure to handle an existing demand that is currently burdening and distorting the function of judicial review. Okay, next we will explain about the subchapter prospect of introducing constitutional complaint in Indonesia as a mechanism to strengthen human rights protection. We talk about the urgency and prospects of introducing a constitutional complaint mechanism in Indonesia by comparing models from Germany and South Korea and outlining potential challenge and implementation models either through constitutional amendment and statutory reform. So as stated by Professor Laguna before, the constitutional complaint, basically, we can see it in Germany and South Korea. It offers valuable insight for Indonesia because these countries with constitutional courts similar to Indonesia demonstrate how a constitutional complaint can effectively safeguard fundamental rights. In Germany, the constitutional court allows individuals to directly challenge public authority action that violate their fundamental rights, extending to legislative, executive, and even judicial decision. Similarly, South Korea Constitutional Court used this mechanism to get better constitutional system and protect individual rights with its decision being legally binding on state institutions. These comparative models highlight the potential for Indonesia of such a mechanism to provide an ultimate remedy for basic right, ensure government accountability, and reinforce constitutional supremacy. And so basically, Indonesia urgently needs a constitutional complaint mechanism due to the inherent limitation of its current constitutional protection framework. While our Constitution guarantees extensive human rights, the Constitutional Court jurisdiction is narrowly get judicial review of status, leaving a significant legal vacuum as stated before. And this means that violation stemming from executive action, administrative policies, judicial decision, or official omission often lack of legal remedies, and it's leading to systemic injustice. So this phenomenon of constitutional complaint, where individuals attempt to frame concrete right violation as abstract reviews, underscore a strong demand for such a mechanism. So by get constitutional complaints, Indonesia can provide an ultimate remedy for basic right, ensure all branches of government are subject to constitutional right, and reinforce the supremacy of Constitution, thereby translating its human rights guarantees into enforceable constitutional justice. Okay, so here Indonesia has two principal approaches for introducing a constitutional complaint mechanism: the constitutional amendment model and the statutory reform model. The constitutional amendment model, which involves attending Article 24C of the Constitution, offers the highest degree of legal certainty and legitimacy by embedding the mechanism directly into the supreme law. However, this approach faces significant political hurdles due to the demanding procedures for constitutional amendment. A pragmatic alternative is the statutory reform model, which expands the Constitutional Court's jurisdiction through revision to the Constitutional Court law, or we know as it UUMK. This approach is politically more feasible, requiring only the approval of the House of Representatives and the President, while it carries constitutional risks regarding legitimacy. It can be argued as an interpretative extension of the court's existing mandate for judicial review. It's aligning also with the broader concept of the constitutional review. Both models aim to get better constitutional court role as the guardian of the Constitution and ensure effective protection against violation by public officials. So how about the challenge and prospect of adopting a constitutional complaint in Indonesia? So key challenge include a potential influx of cases which could overwhelm the Constitutional Court existing capacity, necessitating strict filtering mechanism and a substantial straining of institutional infrastructure, including more justice and administrative support. Another challenge is the risk of institutional overlap with existing human rights bodies, it requiring clear jurisdictional delineation. However, the prospects are compelling. It will provide an ultimate remedy for individuals whose rights have been infringed, ensure all branches of the government are subject to the constitutional right, and reinforce the supremacy of the Constitution. Overcoming this challenge would solidify the Constitutional Court role as the guardian of the constitutional right and translate our Constitution human rights guarantees into concrete and enforceable constitutional justice. So to conclude our paper, basically our Constitution promises extensive human rights protection, yet a crucial gap exists in its practical enforcement. Our Constitutional Court jurisdiction is limited to reviewing statutes without more extensive remedy. This leads to many constitutional complaints being dismissed. To address this, we must adopt a constitutional complaint mechanism drawing lessons from Germany and South Korea. This would provide an ultimate remedy for citizens, ensure all branches of government are accountable, and more strong constitutional supremacy. While the constitutional amendment offers the stronger legitimacy, a more pragmatic approach could be statutory reform, expanding the court existing judicial review powers. Despite challenge like increased caseloads and institutional demands, implementing this mechanism is vital. So it would transform Indonesia constitution human rights guarantees into enforceable constitutional justice. And we have two recommendations basically for our paper. So Indonesia should adopt a constitutional complaint mechanism to fill the gap in protecting citizens' rights. In the short term, this can be done by amendment the constitutional court law to expand the court power of judicial review under Article 24C. And in the long term, a constitutional amendment will provide stronger legitimacy. This reform will make the constitutional court the ultimate forum for right protection, ensuring that no branch of government is above the Constitution and strengthening both check and balance and state accountability. So that's our recommendation for the constitutional complaint. Thank you for listening.
Thank you, Ibu Jen Natasha and Ibu Nisrina, for your joint collaboration and your great presentation. And now I invite the two respondents in response to the presentation. The first is Bapak Tomasek Rumara from University of Nusa Putra Sukabumi, and the second respondent is Pak Saiful Anwar. First respondent, Bapak Tomasek Rumara. Time is yours.
Am I audible?
Okay. Hello. You have 5 minutes in giving your response.
Okay. Honorable Chair, distinguished judges, and esteemed colleagues and fellow participants, good morning. First of all, I would like to thank the organizers of the 7th Indonesian Constitutional Court International Symposium for the privilege to comment on this insightful and timely paper by Ms. Jane Natasha and Ms. Nisrina. These authors have delivered a rigorous and well-structured argument that exposes one of the most critical gaps in Indonesian constitutional architecture: the absence of a constitutional complaints mechanisms. Their papers convincingly demonstrate that while Indonesian 1945 constitution is rich in human rights guarantees, the enforcement of those rights remains limited. The Constitutional Court's jurisdiction, confined mainly to the judicial review of statutes, has created a legal vacuum whenever violations arise from administrative actions or executive policies, or even judicial errors like the Indonesia omnibus laws. This reality leaves many citizens without effective constitutional remedies. I find the author's analysis of comparative experiences particularly valuable. Both Germany and South Korea, I don't know why he didn't mention Italy as well, it's that constitutional complaints can transform a constitutional court from a guardian of norms into a true guardian of rights. In those jurisdictions, citizens can directly challenge violations by any public authority, and the court's decisions carry binding constitutional weight. This comparison offers Indonesia a strong... Am I audible? Hello?
Continue.
Yeah,
Okay.
you can continue.
Yeah, as I was saying, the comparison offers Indonesia a strong normative and practical model for institutional reform. However, I would like to raise three reflections to complement the author's arguments. Firstly, the introduction of a constitutional complaint must be carefully synchronized with Indonesia's existing human rights institution. As the paper notes, bodies such as Komnas HAM, Komnas Perempuan, and Ombudsman already handle rights-related grievances. A clear delineation of jurisdiction is crucial so that the new mechanism strengthens rather than overlaps with these existing structures that existed. Like secondly, capacity building for the constitutional court will be very essential. Like expanding the court's jurisdictions without reinforcing its institutional resources could risk a delays, like backlogs and also inconsistent jurisprudence. The author's suggestion of a filtering mechanisms and the principle of exhaustion of remedies is not procedural at all. It is vital for sustainability. And thirdly, while the authors present both a constitutional amendment and a statutory reform model, I believe a staged approach could be effective, beginning with statutory interpretation under the Constitutional Court law to build jurisprudential practice, and also followed by constitutional amendments once political consensus matures. This pragmatic evolution would align with Indonesian gradualist reform tradition. And in broader terms, the proposal is not merely a legal innovation, it is a democratic necessity. The constitutional complaint would reaffirm that no public authority, even the president, ministers, honorables, or any authority is above the Constitution of Indonesia, and that citizens have a direct line of defense when their constitutional dignity is at stake. And to conclude, their papers contribute meaningfully to Indonesians' ongoing dialogue on constitutional justice. It challenges us to move from declaratory rights to enforceable rights, and from symbolic guarantees to that of the practical justice. What I meant by that is not only by book or by saying, but it must reflect practically. As Indonesia continues to strengthen its democracy and the rule of law, the institutionalization of the constitutional complaint would really mark a significant step toward realizing the full promise of the 1945 Constitution. Thank you, and I would like to conclude or to summarize with one question I've got for these two people, these amazing presenters. Number one, the question I've got is that, given Indonesia's complex network of existing human rights bodies like the Komnas HAM and Komnas Perempuan, how can the Constitutional Court's new constitutional complaint jurisdiction you are proposing be designed to avoid overlap while ensuring coherent and accessible remedies for citizens like you? So very much. And my name is Thomas Shekumara. I am from Sierra Leone, West Africa.
Thank you, Pak Shekumara, for your response and also your question to the presenter. And then we move to next respondent, Pak Saiful Anwar.
Thank you, Professor Susi. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, distinguished speakers and participants. First of all, let me express my appreciation to the authors. These are Ms. Jen and Ms. Nisrina, for presenting a very timely and relevant paper on constitutional complaint in Indonesia. This topic is important because it touches directly on the protection of citizens' rights and the role of our constitutional court. The paper gives us strong arguments by drawing comparison with Germany and South Korea However, I believe there are three areas that could further enrich the discussions. And then this is my comments. I have three comments. And number one comments about empirical evidence. It would be helpful to see concentrate data on cases in Indonesia that resemble constitutional complaint but were rejected by the courts. This quote clearly illustrates the gap between theory and practice. And number two, political dimension. Beyond the legal debate, we should also consider political barriers, such as elite resistance and parliamentary fragmentation, as well as the importance of public acceptance. And the last one, institutional risks. Finally, while the paper notes the risk of an increases case load, it will be useful to discuss how we make find a filtering mechanism, perhaps learning from Germany's strict admissibility system or adapting it to Indonesia context. Overall, the paper makes a valuable contribution, and this additional perspective help make the proposal even stronger and more realistic. And then after my comment, I have three questions. So allow me to raise three brief questions for the author, Ms. Jan and Ms. Risina. Question number one, from an empirical perspective, do we have any mapping of cases that were essentially constitutional complaint, but dismissed by the courts? This is the question number one. And question number two, from a political constitutional review or political constitutional view, which path is more realistic in Indonesia today? Pushing for a formal amendment of the 1945 Constitution or reinterpretation through revising the Constitutional Court law? And how would you respond to the critique that the second option may be ultra vires, or we call it ultra petita? And the last questions, from a technical perspective, if constitutional complaint is adopted, how should the court filter cases so it's not overwhelmed? Should Indonesia follow Germany's strict models or design its own approach? That's all three my question. And once again, I thank to the author, Ms. Jen and Ms. Nisrina, for their valuable contribution. I hope my comments and questions can enrich our discussion and strengthen the relevance of this important topic. Thank you, and thank you, Professor Susi. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Pak Saiful Anwar, for your response as well as your question. You have three issues that should be considered, and then followed by three questions as well. And for Ibu Jane and Ibu Nisrina, you have, sadly, you only have 5 minutes to answer all the questions because we ran out of time. Please.
Okay, sure. For the first question, so we agreed that the main problem is overlapping from the Constitutional Court with our existing human rights institution like Komnas HAM and Komnas Perempuan. So the main solution, as highlighted in our paper, is to establish precise jurisdictional demarcation. So if we adopt the constitutional complaint without these clear boundaries, we run a serious risk of institutional overlap and confusion. So citizens would not know where to go, and the whole system will become less effective. So the goal of this demarcation is to complement. So the new constitutional complaint mechanism must be designed to support and give better Indonesia existing human rights protection system. It must complement, not compete, the work of other bodies, not break it apart to try to compete with it. And the second, to establish clear boundaries. We need clear rules on what types of cases the Constitutional Court will would handle, and what types must remain under the specialized authority of Komnas HAM and Komnas Perempuan as well. Essentially, the constitutional complaint needs to focus on being the ultimate constitutional remedy, only dealing with the most serious violation of constitutional right by public power. This way, the existing human rights bodies can continue their specific focus and necessary work, ensuring a highly efficient system for everyone seeking justice. And for the next question about the mapping and empirical study, so basically to understand how to implement constitutional complaint, the best empirical studies come from comparative law, because we think that the most important models will look at are Germany and South Korea, or maybe there is another country. So studying their experience is vital, actually on one specific point. It is case filtering. So their systems are designed to handle tens of thousands of complaints, filtering out all but the most significant constitutional issues. This is the main lesson we need to learn from another country to avoid being overwhelmed. Okay, so the next one, law amendment or constitution amendment. Well, I acknowledge that this is the central dilemma. Amending the constitutional court, this is the pragmatic faster path because it's political easier, yeah, as it only requires approval from the parliament and the president as well. It treats the new power as an extension of the court's existing judicial review authority. And amending the constitution, the constitutional reform, this is the ideal long-term path. It gives the new power strongest possible constitutional legitimacy. And the third issue, yes, they might be overwhelmed with handling tons of cases in constitutional court. Well, we need to screening mechanism to filter. We have to filter tons of cases that will be handling by the constitutional court, and we have to detail procedural law. The court needs to develop a specific detailed set of procedural rules just for constitutional complaints. This clarity helps streamline the process, reduce ambiguities, and allows the judges to work consistently and thank you.
Is that all?
Yes, that's all.
Maybe. Okay.
Yes.
Thank you. Thank you also for your response from the presenter. And now I think that we have run out of time. Past 12, and now it's time for us to have a break. I'm not trying to conclude all the presentation, but I want to highlight some of the issue. I think that constitutional complaint is an important means for upholding constitutional rights that guaranteed by the Constitution through the function of the Constitutional Court. However, a wide range of practices from the Constitutional Court throughout the world have seen different approaches to the fulfillment of constitutional rights through constitutional complaint. Thailand, for example, the Constitution grants power its Constitutional Court to handle constitutional complaint. Unlike Thailand, the Indonesian 1945 Constitution is absent to provide constitutional norm in regard to constitutional complaint. And all Indonesian speakers agree on the importance of constitutional complaint because, for example, Professor Palguna, if I'm not mistaken, say that constitutional rights without legal remedy are merely aspiration. But the question now is how to realize constitutional complaint. And briefly, two major proposals are offered by all the Indonesian speakers. The first one is formal amendment to the 1945 Constitution, And the second one is amending law on the Constitutional Court. We are looking forward to seeing whether Indonesia can realize constitutional complaint within the scope of power of the Constitutional Court in Indonesia. Again, I'd like to say thank you to all of the presenter. The first one is His Excellency from the Constitutional Court of Thailand, then Professor Palguna, as well as Ibu J. Natasha and Ibu Nisrina. Many thanks also sent to all the respondents for the first session. In the first session, your response are greatly valuable, not only for the presenter, but also for the participant. Again, thank you. Have a good break time. And now I give again to the Master of Ceremony. Thank you. And you can give your applause to all the presenters and respondents.
Let's give big applause for all distinguished speakers, chair, and respondents for session 1. So, ladies and gentlemen, participants, we will resume the 7th ICCIS at 1 p.m. sharp for session 2. So, we'll be right back.
Cik, ini udah full loh ngirimnya. Tis. Gimana? Cik. Enggak ada suara. Tis. Cik apalagi kalau gitu. Cik, iya. Cik.
engedem a videót.
Az igen, csak őket kéne, hogy lássad.
Igen.
Ladies and gentlemen participants, welcome back to session 2 of the 7 ICCIS. Now I would like to invite the chair for session 2, Mr. Saru Arifin, SH LLM PhD from University Negeri Semarang. Please.
Well, thank you very much, Master of Ceremony. Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. It is a very pleasure to I invite you all to come to our session today. At this session, we have many speakers, literally, but they come from 3 countries. The first one is from Hungary, and the second one is from Azerbaijan, and the third one from Madagascar. Let's kick off our first speaker from Hungary. I would like to invite Professor Dr. Agnes Sin, Zuragit Kivanok from Hungarian time.
Good afternoon.
Or Silabot Kivanok, Indonesian time. I'm a graduate from Faculty of Law at the University of Perth, so I know a little bit of Banjar. So it's so glad to meet you here, Professor Sims. And we have a respondent or a discussion for your presentation today. Professor Susi Dwi Haryati from University of Pajajaran, Indonesia, and Mr. Eri Satria Pamungkas. Professor Sin would like to present her papers regarding the fundamental rights protection through constitutional compliance with special respect of its effectiveness in Hungarian examples. So you have 15 minutes, Professor Sin, to present your paper, and the rest time 5 minutes for each respondent to give their opinion, respond, or question for your presentation, and the rest 5 minutes for question and answer. Then we will conclude at yes minutes all, and then move to the next speaker. Time is yours, Professor Agnes Sins.
Yeah. Good morning. In Budapest is good morning, but in Indonesia, in Jakarta, it is afternoon. Good afternoon. I would like to greet the director, the president of the Constitutional Court, and all of them, the participant of the conference. I would like to publish my slide. It is possible. Yeah. It is. Can you see me? My slide?
It is not yet appeared in our.
Not yet?
Yes,
Oh.
but at the beginning
Yet. Thank you so much. My topic is fundamental rights protection through constitutional complaints with respect of its effectiveness. Ladies and gentlemen, I would like to extend a warm welcome to constitutional justices and colleagues from around the world who are participating in this symposium, which raises and analyzes interesting topics related to constitutional complaints. I would like to thank the Indonesian Constitutional Court and all its staff who organized this important event for giving me the opportunity to hold presentation. I will try to summarize briefly my analysis of some of the problems concerning the effectiveness of constitutional complaints with special respect to the Hungarian model and the effectiveness of it. I would like to share my experiences of my 10-year tenure as a constitutional judge regarding the effectiveness of constitutional complaints. Nowadays, The Hungarian constitutional complaints is an effective legal remedy, the effectiveness of which has been recognized by the European Court of Human Rights. Before submission of application, the petitioner has to exhaust the domestic legal remedy. However, from the aspect of effectiveness, the ICCIS emphasized that it is up to the applicant to decide which type of constitutional complaint to file in order to achieve the success that is the change of the ordinary judicial decision or the piece of legislation. Based on this idea, I have identified some of the key points that need to be known in order to assess the success of the constitutional complaint procedure. The effectiveness of constitutional complaints depends on different factors, of which I would highlight the following. It is fundamentally influenced by the filtering criteria and the legal consequences determined by the legislator, as well as by the practice of fundamental rights protection developed by the Hungarian Constitutional Court. As to the filtering factors, I have to mention the interpretation of the content of the fundamental rights protected, the determination of issues of fundamental constitutional significance, and the strictness of formal requirements. In this presentation, I would like to raise a few points that show, based on Hungarian experience, how all these circumstances could influence the success of complaints. I would like to briefly introduce the types of constitutional complaints that can be filed in Hungary. According to the rules in force, there are 3 types of constitutional complaints under the Act on the Hungarian Constitutional Court. First, I will refer to this type as normal constitutional complaint that aims to establish the unconstitutionality of the piece of legislation applied in court proceedings and at annulling the provision itself or the court decision or both of them. The second type of our constitutional complaint is the so-called abstract complaint, whose target is exclusively establish the unconstitutionality of a legal provision without legal suit or procedure. The Constitutional Court could annul it if, as a result of the application or enforcement of the legal provision, the petitioner's right guaranteed by the fundamental law has been directly infringed. In this case, no court or administrative proceedings are necessary, only that the legislation directly infringes the applicant's rights and there is no possibility of legal remedy. The difference between the normal and the abstract complaint is that in the case of the normal complaint, the infringement of rights results from the application of the law in court proceedings. In the other case, the infringement occurs directly from the law without a court decision. Until 2012, the Hungarian constitutional complaints was an ex post review of legal rules, like nowadays the abstract constitutional complaint. This complaint seems to be an actio popularis. However, in the case of actio popularis, anyone can file a petition, but in the case of the formal constitutional complaint, the Constitutional Court also required that the petitioner be concerned. The petitioners had to exhaust all other legal remedies or had no other legal remedies available to all other legal remedies to them. After 2012, the direct constitutional complaint required stricter proof of involvement because it must be personal, direct, and current. The third type of constitutional complaint is the so-called genuine constitutional complaint. This real complaint seeks to annul exclusively the decision on the merits of a court case or a judicial decision, otherwise concluding court proceedings if the decision violates the petitioner's fundamental rights. This type of constitutional complaint accounts for most of the cases brought before the Constitutional Court. The Constitutional Court is not an ordinary court of fourth instance. The laws are primarily interpreted by the ordinary courts. Therefore, the Constitutional Court refrains from taking a position on the validity of the issues pertaining to legal dogma and has no jurisdiction to review the direction of decisions, the judicial assessment of evidence, or the entirety of court proceedings. The two types of complaints best serve subjective legal protection are those that are directed against judicial decision. It can break the final decision and compel the ordinary court to conduct a new proceeding. In contrast, complaints against norms bring the interest of a community before constitutional review and operate at a higher level of abstraction, making them often more difficult to justify than a specific case. It is no coincidence that the abstract constitutional complaint in force in the earlier period of the Constitutional Court left a sense of deficiency among the legal remedies of the legal system. Constitutional complaints may be lodged in defense of fundamental rights, but it has also included certain legal principles in this category. The prohibition of retroactive legislation and the reasonable period of time granted to prepare before the legislation enters into force, which are the principles of legal certainty and ultimately the rule of law. In this way, it has broadened the list of fundamental rights taken from the classic human rights catalog on which complaints can be based. Most constitutional complaints fail because of formal requirements. The person or organization submitting the constitutional complaint must take into account these factors. They must be aware of the content of the fundamental right as well as the relevant practice of the Constitutional Court, and must also submit a justification for the violation thereof. Without a constitutional justification, the complaint cannot be assessed on its merits. According to a statistical research based on decisions made between the last 10 years, it can be established that the most frequently invoked and educated rights guaranteed by the fundamental law are the right to a fair trial, equality before the law, the rule of law, the right to property, the right to legal remedy, freedom of expression, and freedom of the press. The practice of applicants, which indiscriminately refers to all rights and articles that are even remotely related to the grievance in the layman's view, has been transformed into the invocation of general articles that contain several partial rights in the hope that they may arouse the interest of the Constitutional Court. The typical ground is fair trial and rule of law. Let's us look at the statistic. The statistical data clearly show the extent of the caseload of constitutional complaints within the listed powers of the Constitutional Court, based on the data between 2012 and 2024. The number of completed cases was distributed as follows. The overwhelming majority of complaints were dismissed or rejected. Only a few complaints were successful in that they resulted in a change in court decision or legislation. 93% of all decisions made by the Constitutional Court last year were constitutional complaints, and 82% of these were directed exclusively against judicial decisions concluding proceedings. With a relatively small margin of error, we can say that this ratio has generally remained the same over the past 10 years. If we ask how many percent of constitutional complaints result in legal consequences, such as a court ruling or the annulment of the applicable legislation, then the 5 to 6 success rate may seem low. The reason for this is, on the one hand, the structure of constitutional complaints, and on the other hand, the applicants and the law enforcement lawyers' level of knowledge. According to the complaint structure, I have to refer to the fact that the Hungarian Constitutional Court was established on a centralized model of Kazan, and its detailed rules were based on the German Federal Constitutional Court. In its more than 7 decades since the establishment of the Federal Constitutional Court in 951, it was 95% of the cases it has adjudicated have been constitutional complaints, and as I was informed that the number of complaints resulting in a favorable outcome for the applicant is similar to the Hungarian results at approximately 2 2 to 5%. Due to time constraints, I would just like to point out that the definition of legal screening criteria fundamentally influences the number of complaints that can be submitted. The circle of applicants, the number of fundamental rights that can be infringed, the deadlines, the determination of the applicant's involvement, the types of court decisions that can be challenged, and the formulation on question of fundamental constitutional significance can all be restrictive or expensive criteria. On the other hand, it is highly advisable for the applicant to consider whether a constitutional complaint is suitable for resolving or remedying the legal injury in question. Today, the Constitutional Court has a well-established practice in relation to constitutional complaints, which provides assistance in this regard. The case law of the Constitutional Court makes it possible to determine with a high degree of certainty which of the three types of constitutional complaints currently in existence is likely to be successful in a given case. However, the majority of complaints do not currently consider this issue with sufficient thoroughness, which is why a large number of complaints are rejected on the merits. It must be taken into account that the Constitutional Court is not the fourth level of the ordinary court system, but a body that conducts examinations based on constitutional criteria and can provide special legal remedies in these proceedings to applicants who have suffered harm because of the administration of justice or legislation. Thank you for your attention.
Question number 7. Thank you very much, Professor Agnesin, for your great insightful presentations for us, the perspectives from the Hungarian Constitutional Court's practices, the citizen complaints, that there are two types of complaint there, normal and abstract, and with their details and the adjudication mechanism. So, Drake, I would like to call Professor Susi Dwi Haryanti to give your response for Professor Agnesin's papers and presentation, and then Ms. Feni Tri Purnamasari. Time is yours, Professor Susi.
Thank you, Dr. Saru Arifin, for your opportunity. Firstly, I'd like to say my highest appreciation to Professor Sidney for your systematic, comprehensive, and coherent presentation. And you proceed your presentation with a very succinct, abstract, but with a very solid argumentation. You proceed with the constitutional complaint is a modern, functional, and effective legal remedy. This is a very strong words for me, strong sentence for me that show your solid position or your solid standing in regard to the function of constitutional complaint. And then you focus your presentation in terms of the effectiveness of the constitutional complaints, that according to your argument, the effectiveness of the constitutional complaint depends on filtering criteria and legal consequences that determined by the legislature, as well as by the practice developed by the Hungarian Constitutional Court. Then you move to the concept of effectiveness, and afterward you explain about the model of constitutional complaint, then the constitutional complaint procedure, and finally you close your presentation with a conclusion. So your presentation indeed provide a good best practices to the other constitutional court throughout the world, in particular for Indonesia. However, apart from the successful of the Hungarian Constitutional Court dealing with effectiveness of constitutional complaint, I would like to raise my question to you. Is there any concern or weakness of constitutional complaint, for example, in the context of procedure weakness, whether the issue of the limit time of submission become a factor that should be considered? And is there any weakness in the broader context within the whole system or the broad system in Hungary? For instance, is there any concern dealing with the rule of law culture, or also is there any concern dealing with the political culture, even though that the Constitutional Court is not dealing with the political, perhaps the political question, but we know that the political culture is also playing an important role for the successful role playing by the Constitutional Court. Thank you.
Thank you, Professor Xi, for your insightful response and also the questions. And the next one is welcome to Ms. Fanny Tripunamasari. Time is yours.
Okay. Thank you, Chair. Good afternoon, everyone. Her Excellency, Prof. Dr. Agnes Sin, speakers, all respondents, and esteemed participants. I'm Fanny, the Substitute Registrar on Constitutional Court of Indonesian team. It is an honor to respond very insightful paper entitled Fundamental Rights Protections through Constitutional Complaints with special respect of its effectiveness from Prof. Your analysis of the Hungarian Constitutional Court jurisprudence provides a very rich framework for understanding how constitutional complaint can serve as both an institutional safeguard and practical remedy for citizens whose rights have been violated. Your argumentation offers profound reflection on how the Hungarian model evolved from an abstract norm control system to a genuine individual rights protection mechanism. What is most compelling is your focus on effectiveness, which you define not simply as the affability of procedural remedy, but as the real capacity to restore constitutional rights. Professor Zins, you emphasize that constitutional complaint is effective only when it provides substantive redress, when it can correct or nullify judicial decision that violates constitutional guarantee. Hungary's constitutional complaints serve as both a shield for the individual and mechanism to harmonize domestic constitutional law with international human rights standards at ICCIS. And then comparative reflection from the Indonesian perspective, the Hungarian experience over both very inspiring and challenging. As the speaker before, Mr. Palguna said, that Indonesia has no constitution authority to constitutional complaints. Hence, Indonesia can make small revision on constitutional law without changing Amendment 1945 Constitution. Under Article 24C1, the 1945 Constitution, the Constitutional Court of Indonesia, Mahkamah Konstitusi, exercise judicial review of statutes, resolve institutional disputes, overseas election dispute, and considers impeachment about president and vice president. But it doesn't yet recognize that individual constitutional complaint. This means that Indonesian citizens may only challenge the constitutionality of law, uji material, not the constitutionality of final judicial decision on constitutional. As a result, when a lower court misapplies the law in a way that infringes upon constitutional rights, the citizens only recourse in cassation mechanism or judicial review by the Supreme Court of Indonesia. And of course, the process focuses on the legality, not constitutionality. Now, I want to ask to Professor Zins. The question is, Professor, based on your judicial experience and your analysis of Hungarian models, how can a constitutional court maintain a delicate balancing between ensuring effective individual rights protections through constitutional complaint and preserving the finality, certainty, and authority of judicial decision, particularly when the constitutional complaint challenge is a final court judgment? This question is matter for me because for a system like Indonesia's, which aspire to adopt constitutional complaint mechanism but remains cautious about creating overlapping the Constitutional Court of Indonesia and the ordinary judiciary. Your insight into how the Hungarian court managed this balance will provide valuable guidance for jurisdictions seeking to evolve from the abstract norm control to the individual rights protections. That's all. Thank you, Professor.
Thank you, Ms. Fanny, for your great question regarding the presentation from Professor Agnes Sin. But before I give time to Professor Sin, I would like to call for one question from the audience, if any. Please speak directly, if any. If not, I would like to give the time to Professor Agnes Sin. Any from floor? It seems nothing. So please, Professor Agnes, which one do you want to respond first? From Professor Susi or from Reni? Anyway, it depends on your availability. Time is yours. Sorry, your voice is not listened yet. Professor Agnes.
Thank you so much for the questions. There are very important questions. I said so. We have in the constitutional procedure very important fundamental right, whereas the relevant practice of the Constitutional Court and must all submit a justification for the violation thereof. I needed to say very important right, the right to fair trial, equality before the law, the rule of law, the right to property, the right of legal remedy, freedom of expression, on the freedom of the press. These rights are in the fundamental law art, and our decisions are very important in today and yesterday legal practice in the court. Because we have a lot of possibility. For example, we can the court decisions annul, and we give other possibility. And I would like to say it is a very important question not connect this with these questions formal criteria of the petition. It is a very, very important. The petition has to be submitted in written form on the filed with the Constitutional Court, or in case of constitutional complaint at the Court of First Instance. No procedure shall be started upon a petition as submitted by email. The petition has to include the name and address or seat of the petitioner, and if the petitioner is a public law official, his or her office. And very important, the proceedings of the Constitutional Court are free of charge. It is a very important right because the popular coming to Constitutional Court. And yes, that's all.
Well, thank you very much, Professor Agnes Sen, for your response and answer for all the questions. Unfortunately, because we have a limited time, we cannot extend our question and answer. And again, thank you very much to Professor Susi and Ms. Feni for your time, for your feedback. Also, Konsenam to Professor Agnes Sen, Sia, for your insightful presentation today. So, we move to the fifth speaker today. We have three speakers from the Constitutional Court of the Republic of Azerbaijan. The first I would like to call his Mr. Rauf Guliev, Ms. Sabina Mirzayeva, Ms. Arzu Alea. They will present their paper entitles the procedures of examination of constitutional complaints by Constitutional Court of the Republic of Azerbaijan. And for your papers, we have two respondents or discussants here. The first one is Professor Dr. Muhammad Ali Safaat from University of Brawijaya, Indonesia. And the second one is Dr. Suryo Gilang Ramadan from Constitutional Court of Indonesia. Excellency, His Excellency Mr. Rauf Guliev and team, you have 15 minutes to present your papers. Start from now. I don't hear yours. Would you like to check first your speaker, maybe? I'm sorry, your voice is not clear here.
It's okay now? Now it's
Okay,
clear?
yes, please. Would you like to present your screen, maybe?
Yeah, thank you very much, Mr. Chairman, for giving me a floor. I want to say that it will be only my presentation. Two other participants are just the partners of the Constitutional Court. They are working with us and the staff in the Secretariat. They are just the participants, so it will be only one presentation submitted by me. First of all, on behalf of the Constitutional Court of the Republic of Azerbaijan and Chairman Dr. Farhat Abdullayev, I would like to thank the Constitutional Court of the Republic of Indonesia and especially Honorable Chief Justice Dr. Sukartoyo for initiative to hold the 7th Indonesian Constitutional Court International Symposium. I also greet all my colleagues from foreign constitutional courts, honorable scientists and legal researchers, and wish all of them health and prosperity. Dear colleagues, the authority to examine the constitutional complaints is regulated by Constitution of the Republic of Azerbaijan and the law on the Constitutional Court of the Republic of Azerbaijan. According to Constitution, everyone can lodge a complaint with Constitutional Court against the normative acts of the legislative and the executive, as well as the acts of municipalities and judicial acts, which violate the rights and freedoms. Here, the notion everyone implies every person and not only the citizen Republic of Azerbaijan. The constitutional complaint procedure is regulated in the law on Constitutional Court as well as in the internal rules of the Constitutional Court. A complaint against judicial act is allowed in case where the relevant decision of the Supreme Court of the Republic of Azerbaijan, which is challenged, is based on a normative legal act that does not comply with the Constitution and other laws of the Republic of Azerbaijan. Here I have to underline that the complaint can be submitted to Constitutional Court after exhaustion of all judicial remedies. However, the law on Constitutional Court provides that if the legal protection of constitutional rights by means of ordinary jurisdiction cannot prevent the imposing of serious and irreplaceable damage to complainant, then the complainant can apply directly to Constitutional Court. Once the complaint reaches the Constitutional Court, the Secretariat preliminary examines it within 7 days. As a result of the preliminary examination, the Secretariat of Constitutional Court may forward the complaint to relevant state authorities if it is clearly evident that it does not fall within the jurisdiction of the Constitutional Court. If it's clearly evident that the complaint does not comply with the formal requirements envisaged in the legislation, the Secretariat may advise the applicant to comply with those requirements. After the complaint is duly drawn up, the Secretariat prepares the report on complaint to be submitted to the Chairman of the Constitutional Court. Then one or several reporter judges shall be appointed for preparation of session on preliminary study of complaint. A reporter judge shall prepare the report on the case concerned and bring it to the session of the panel of judges. Here I have to mention that there are 2 panels in the Constitutional Court, and in each panel there are 4 judges, and the chairman of the court can also participate of the panels as additional judge. The panel decides whether to admit the complaint for examination of plenum that consists of full composition, that is of 9 judges. The ruling of panel is adopted by a majority of judges, while the final decision of plenum shall be adopted by at least 5 judges. Hearing of cases in Constitutional Court shall be public. The hearing of a case in camera shall be admissible only when Constitutional Court assumes that public sessions can become a reason for disclosure of state, professional, or commercial secret, or when it reveals the necessity to protect private or family life of citizens. The decisions of the plenum of Constitutional Court shall have binding force on the territory of the Republic of Azerbaijan, and once the Constitutional Court determines that the normative legal act which the decision of the Supreme Court is based on does not comply with the Constitution and laws of the Republic of Azerbaijan, this leads to re-examination of that decision. A total of 257 rulings were adopted by panels since January of this year. Currently, 55 complaints are being examined in the panels of the Constitutional Court, and their destiny will be decided in the session of the panels, who will adopt the final ruling whether to adopt any of them for the examination of the plenum. In the end, I would like to thank once again the Constitutional Court of the Republic of Indonesia for holding this event, and to wish all the best and successful holding of this symposium. Thank you very much for this presentation. Once again, I want to mention that it is the only presentation. Other participants, they are just attending at the symposium, and they will not make any presentation on behalf of the Constitutional Court of Azerbaijan. Thank you.
Well, thank you very much, His Excellency Mr. Rauf Guliev for your concise, simple, and yes, clear presentation regarding the constitutional compliance. I can summarize 2 things here. The first one, that the constitutional complaint can be submitted directly by the citizen to the constitutional courts if they found their rights violated by any of laws or policies from the government or agencies, either legislative, executive, or judicative. So for their complaints, and then Constitutional Court within 7 days will hold the preliminary examination to determine the contents of the complaints compliant with the Constitutional Court authority or not, etc. So to elaborate more for your presentation, I would like to call our respondent. The first one, Professor Dr. Muhammad Ali Safaat, and then Dr. Suryo Gilang Ramadan. Each of you have 5 minutes to give your response. Time is yours.
Thank you, Chair, Dr. Saru Arifin, and very thank you, His Excellency Mr. Rauf Guliev from the Constitutional Court of the Republic of Azerbaijan. Thank you for the brief, clear, and insightful speech that I think it's very interesting for the Indonesian. And you mentioned that the constitutional complaint based on the constitutional court law in Azerbaijan, that everyone might apply constitutional complaint case, not only the citizen. So it is very interesting because in Indonesia, we don't have the authority, the constitutional court don't have the authority to try the constitutional complaint case. But for the judicial review case, the Constitutional Court Acts in Indonesia clearly stated that the individual that apply case Constitutional Court should be Indonesian citizen. And I think we have one case is that foreigner apply cases to the Constitutional Court at the time. I think it's concerning the Act of Psychotropica. But the Constitutional Court decided that case inadmissible because the Constitutional Court Act clearly stated that individuals should be citizen. Even at that decision, I think there is one judge that delivered dissenting opinion. So I think this is interesting. And could you please to explain the maybe argumentation or the background why the Constitutional Court in Azerbaijan have the Constitutional Court have give the legal standing for everyone, even the foreigner, not only the citizen of the Republic of Azerbaijan. Or maybe you kindly please to give the example. Is there any case that submit by the foreigner to the Constitutional Court of the Azerbaijan? The second one, even principally, that the complaint submitted to the Constitutional Court Azerbaijan should be exertion of all judicial remedies. But you also mentioned that law on Constitutional Court of the Republic of Azerbaijan provide that if their legal protection of or constitutional right by means of court ordinary jurisdiction cannot prevent and irreplaceable damage to complainant, that the complaint can be submitted directly to Constitutional Court. Maybe I curious what the condition by the main court of ordinary jurisdiction cannot prevent the imposing of serious or irreversible damage. This is the condition, the ordinary court, or the condition of the law that will be applied by ordinary court, or depend on the sanction in the law that will apply by the court. So this is very interesting. Thank you very much.
Thank you, Professor Ali Safat, for your question. And the next one, I would like to call Dr. Suryo Gilang Ramadan. Time is yours.
Okay, thank you so much to Chair Mr. Saru Arifin and His Excellency Mr. Rauf Juliev. And I would like to give my honor to Mr. Professor Muhammad Ali Safat. Excellency, I would like to say so many thanks for your comprehensive presentations. And I learned so many things. I got so many information and knowledge, especially about the constitutional complaint. Well, for your information, this topic, I mean about the constitutional complaint, is the one of the interesting issues that is currently being hotly discussed in my country. In fact, the Constitutional Complaint Authority is also being considered for implementation in the Constitutional Court of Indonesia. Based on these facts, I then observed the presentations from the speakers, Excellency Mr. Rauf Juliev, who explained the Constitutional Complaint Authority of the Constitutional Court of Azerbaijan. Regarding this matter, I have 4 questions, maybe for the speakers about the constitutional complaint in Azerbaijan. First, as we all know, the opening of the constitutional complaints has the potential to encourage citizens to flock to the Constitutional Court of Azerbaijan. Given the large number of cases received, what is the strategy of the Azerbaijan Constitutional Court to ensure that this large number of cases can be handled effectively within the stipulated time frame? And for the second, I would like to ask about the distribution of the cases. How are the cases distributed to the judges who will handle them? And to what extent can the supporting system of judges in the Constitutional Court of Azerbaijan provide support to the judges? And as far as I understand the Constitutional Complaint Authority, there is a possibility of overlap with the Judicial Review Authority. And the question is, how does the Constitutional Court of Azerbaijan address this? How to identify the difference between resolving a constitutional complaint case and resolving a judicial review case? And for the last, I would like to ask about the structure of the institutional Constitutional Court of Azerbaijan. Maybe the specific is about the consequences for the implementation of the constitutional complaints. The question is, has the implementation of constitutional complaints, which has resulted in an increase in the number of cases, also resulted in the need for additional personnel, both a judge or support systems? I think that concludes my response to the speakers today. Once again, I would like to emphasize that what the speakers have presented is very interesting information and knowledge, especially to Indonesia, as we are currently discussing this topic. Therefore, on this occasion, we learned valuable lessons from the Constitutional Court of Azerbaijan. Hopefully, this overview of the implementation of Constitutional Complaint Authority in Azerbaijan can inspire all of us in Indonesia, especially in Constitutional Court of Indonesia. Thank you so much.
All right, thank you very much, Dr. Suryo Gilang Ramadan, for your response and also the question. But because there are so many questions addressed to His Excellency Mr. Rao, so The question from audience will be allocated after Mr. Rao Guliat give his answer to all the question addressed by Professor Alispat and also by Dr. Suryo. Time is yours, Her Excellencies, Mr. Ralph Guliat.
Thank you so much for interesting questions. Really, they touch upon the legal, scientific, and practical issues. I will try to uncover them issues which were touched upon in these questions. So regarding the access of the citizens and the persons to Constitutional Court, yes, everyone can address to Constitutional Court. That means that any also foreign citizen and the stateless person can apply to Constitutional Court. And we had the cases where the foreign citizens applied to our court, and among them was also the decision of Clark Morris, the citizen of United Kingdom, who applied to court, and the plenum of the Constitutional Court adopted the decision interpreting the legislation regarding the proportionality of application of the law on the civil legislation in conjunction with the guarantees and freedoms connected with the freedom of movement, which are envisaged in the Constitution of the Republic of Azerbaijan. Concerning the notion of damage, who determines the damage that can be imposed to any citizen who wants, or any person who wants to apply to court, and in order to prevent this damage, the Constitutional Court, as I said, can examine the case without necessity to exhaust all the remedies. This depends directly to the position of the Constitutional Court, and it is only the Constitutional Court who can define whether this damage really can be imposed. There was also the decision of the plenum of the Constitutional Court where we admitted the complaint without requiring to pass this complaint through all the judicial instances. It was the case of Javidan Huseynov, the citizen who applied to Constitutional Court regarding his right to education, and he challenged the norms regulating the right to education, and therefore the Constitutional Court admitted it for examination and adopted the decision guaranteeing his right to education. And this norm regarding the necessity to prevent the damage was applied in this case. So, in generally, regarding the number of the cases and the constitutional complaints which arrive or which reach the Constitutional Court, approximately we can say it's about from 6 to 9 constitutional complaints who come to our court. Generally, they are just complaints because when we make any kind of, or when the Secretariat makes any kind of, let's say so, monitoring or filtering of these complaints, finally, it's only 10 or 15% of these complaints who are directly related to the functioning of the Constitutional Court. Most of the complaints, are directed against the actions of some institutions which are not related to the functioning of the Constitutional Court. Sometimes our Secretariat advise to the complainant to change, to modify the complaint in order to make it, let's say so, directly constitutional one and to apply again to the Constitutional Court. In this case, we advise them to fix the documents, to fix the complaints, and to have once again the access to our court. And regarding the distribution of the cases in the Constitutional Court, it depends directly on the influx or the load of the judges. So it depends on the cases we distributed among judges, and the chairman of the Constitutional Court, the person who can allocate the cases among them, depending on the occupation of the judges. And regarding the judicial case and the Constitutional Court case, what is the difference between the examination of these two types of case? It is true that the Constitutional Court, when examining any case, first of all, pays attention whether the normative legal act which was applied by the court contradicts the Constitution, or it is okay. If it does not comply with Constitution, then Constitutional Court, first of all, shall declare that this normative legal act is not in conformity with Constitution, and then it will bring to the re-examination of the judicial act. In fact, the judicial decision itself is not under direct revision by the Constitutional Court. The Constitutional Court pays attention, first of all, on the legislation which was applied during examining any judicial case, and finally, which was applied in the any kind of the judicial decision. And regarding the enlargement of the staff and the number of the judges, I guess that for a time being, we have quite enough number of the employees in the secretariats who can cope with the complaints coming to the Constitutional Court. We have 9 judges. As I said before, they are divided into 2 panels. For the time being, the lot of the cases and the lot of the complaints can admit us to function effectively, as I think. So that is the general responses. If you need any kind of other clarification, I will give it with a big pleasure. Thank you.
All right, thank you very much, Excellency Mr. Rauf Guli, for your insightful response and yes, feedback for your Professor Ali Safaat and Dr. Suryo Gilang questions and remarks for your presentation. Again, thank you very much for all of you, but sorry for the audience, I cannot give you an opportunity due to we have exceeded almost 10 minutes from our schedule for the 5th speaker. So again, thank you very much, His Excellency Mr. Rauf Guli, our responder, Professor Ali Safaat and Dr. Suryo Gilang Ramadan. And now we move to the speaker 6 from Madagascar. The first one is Mr. or Mrs. Ramalina Mikea Manitra from Asta Research Center Antananarivo, Madagascar, and Dr. Adia Paramita Prabandari, I guess this is from Diponegoro University. Their paper is Judicial Independence at Stake, Constitutional Compliance and the Perceived Immunity of Political Elites in Madagascar. And for your paper, we have 3 respondents. Bimo Fajar Hantoro, Fatima Azahro from University of General Sudirman, and Dr. Wilma Silalahi from Constitutional Court of Indonesia. Your time is 50 from now.
Okay. Is my screen visible?
Yes, it is.
Okay. So to the honorable judges that attend this meeting, honorable professors and doctors, and honorable fellow speakers as well. Good afternoon. My name is Manev Mikea Manitra. and I'm presenting this paper entitled "The Judicial Independence at Stake: Constitutional Complaint and Perceived Immunity of Political Elites in Madagascar." First of all, I would like to thank the committee of Indonesian Constitutional Court International Symposium to be selected as one of the speakers. It is a very honor to be one of them. So as a disclaimer that this paper is not addressing in its full entirety the constitutional complaint, but more on why Madagascar needs constitutional complaint in mechanism itself. So there will be several reasons, case studies that we're going to see, and in terms of judicial independence, and at the conclusion, we're going to see whether the constitutional complaint is needed in the country or not. So as the first, for your information, Madagascar does not have constitutional complaint mechanism in the constitution itself. So the Constitutional Court of Madagascar is only given power to adjudicate the electoral issue, to judicial review, and to proclaim the result of the general election. However, what we are putting here as the main theoretical framework of this analysis is that there are two rights that needs to be protected, especially in terms of constitutional and before the Constitutional Court. Those are the access to justice and equality before the law. And the High Constitutional Court of Madagascar, by the Constitution, is considered as the guardian of the Constitution. However, there is an issue that appeared actually since 2009. It impacts the trust of the public towards the Constitutional Court itself, as judicial independence is at stake since the decisions from 2009, 2018, 2023 concerning one political actor, which is the actual president of Madagascar, Mr. Andry Rajoelina, is creating distrust of the public and the questions on the judicial impartiality. So the main question that we're going to answer is there a constitutional immunity in Madagascar? Is it a legal reality or just a mere impression of the public? And at the conclusion, we're going to see whether the constitutional complaint can be a solution for the country in such issue. So before we go into deeper analysis of those decisions, there needs to be a brief background of why this study focused on one political actor. So the political actor that is being spoken about here has conducted his career in 2007, gaining popularity and having media TV. And he was elected mayor of Antananarivo at the time. In 2009, he conducted a coup d'etat against the president at that time, President Ravalomanana, which he succeeded. And the Constitutional Court, despite noticing that there was an unconstitutional order going outside of the Constitution, since this was a coup d'etat, still give the power to him that we're going to analyze later on. 2009 to 2014, he was the head of the transition, and he did not participate in the electoral in 2013. While in 2018, he came back in power, still politically influent, and many decisions were challenged as well as to his candidacy, as he was the main actor of the coup d'etat. But the Constitutional Court still approved his candidacy at that time and leading to his winning of the election. He did his first term, and in 2023, he did his second term, to which it was known that in 2014, he has obtained the French citizenship. And by the law of Madagascar, if you want to be a president, you need to be Malagasy, have the Malagasy citizenship. But such were such challenge were ignored as well, disregarded, and given the favor to the president actual. We use a doctrinal legal research method in this, and some comparative analysis as well to provide insight. So for the legal framework of constitutional justice in Madagascar, the Constitutional Court, as provided by the slides here, it has authority on doing a constitutional review of laws, electoral disputes, and to proclaim also the result of electoral presidential. And as for its institutional and organization jurisdiction, it is done under the organic law number 2018-008 on the general regime of election. It has main authority on that to adjudicate if any possible conflicts arise to that, as well as it gives power as well under the organic law 2018-008 regarding electoral operation and proclamation of results. So here are the decisions that we're going to analyze in concerns of this main political actor. In 2009, two main political actors two main decisions were rendered by the High Constitutional Court of Madagascar, which is, as you can see here, in 23 April 2009 and in 31 July 2009. And in 2018, two decisions as well in 2023, there were 4 decisions. Now let's see what happens in 2009. So for your context, as I have explained before, in 2009, there was a coup d'etat that was conducted by this political actor against the president at that time. So the president, the former president Ravalomanana, has make ordinance number 2009-001 and given the power to the military directorate, given the power to the president Andra Jelina, which is outside of the constitution, because based on Article 52 of our constitution, if the president is impeached, then the president of the Senate, the parliamentary, have to step up for him. And if such president of Senate is unable to take the position, then the function of the president of the country will be done collegially by the government. But ignored on the Article 52 of the Constitution, the High Constitutional Court has reasoned its decision based on the continuity of the state, and it is better to give the position to the political actor, which is Andra Jelina at that time. It violates the principle of constitutional supremacy, and it validated as well a de facto regime, which has no legal basis. In 2018, this main political actor as well returned into the presidential election, and there was a constitutional challenge on the decision 26 ICCIS D3, in which the complainant has said that a coup d'etat, a person who has conducted a coup d'etat should not be eligible to run for the presidential election. However, the Constitutional Court has dismissed the complaint based on procedural grounds without examining the merits relating to it, stating that the Constitution of Madagascar does not prohibit people who conducted the coup d'etat to run for election. And here we have a comparative insight that can make a lesson also for Madagascar. For example, the US Constitution on its 14th Amendment, Section 3, it prohibits any people that went against the Constitution to run for any position, such as senator, representative in Congress, or president or vice president for the country. So here the question rises on first, the constitutional morality in terms of ethics, because constitutionalism is not only the protection of the Constitution as a document, it is the protection of the Constitution as in its entirety and its application. And the second is in terms of democratic integrity and the access to justice of the people. In 2023, as I have mentioned before, the context was that this main president also was discovered to have a French naturalization, so he acquired the French citizenship in 2014. Such facts were presented to the High Constitutional Court, but was denied based on conflict of competence, because based on the nationality law of Madagascar, it is stated that the court of first instance has the competence to adjudicate the nationality issue. However, the question here arises, lex superior in terms of the constitution giving the power to the constitutional court on matters of election, and the lex specialis in terms of giving the court of first instance to decide the nationality issue. No transparency was given at that time, and it led to political public distrust, and also the denial of justice for all the claimants that given their issue to the Constitutional Court. So the main question that arises here is on whether there is a potential constitutional immunity. So based on all the decisions that we have given before, it is difficult to say that there is a de jure recognition of the constitutional immunity of President Andrade. However, the restrictive judicial practices that were shown before have produced the same effect. And here we can see that, as we have mentioned before, two rights were violated: access to justice and equality for the law. One question: why the Constitutional Court should always make in favor of one political actor in terms of its decision and not giving any reasoning for the challenge that is given to it, only based on formalistic denial of such challenge. And the second is access to justice. Only political actors that are involved to this issue can raise to the problem. However, there are a lot of people that weren't accepting this, and it's such right violates the Article 25 of ICCPR, which gives the mandatory to the state to respect the right of political to the citizens. So this situation, it has not only happened in Madagascar, but in several countries in Africa as well, such as in Benin, in terms of judicial credibility, weakened by political representation bias, in Angola, biased post-political litigation, and in Ghana, executive dominance. So those examples can show that this issue is happening in Africa, but it's happening also in Madagascar. And Madagascar, as a country that does not have the constitutional complaint mechanism, is at the verge of abuse of power, I would say, and it needs to protect the right of its citizens, namely here the political rights. So in conclusion, the High Constitutional Court has upheld its obligation only formally, without addressing substantially the issue that were raised by the complainants at that time. And there is also a selective interpretation. In terms of constitutional complaint, to answer the question, yes, indeed. Madagascar needs to have a constitutional complaint mechanism, especially in terms of how the citizens can express their political rights and how this will be more protected in terms of this kind of injustice. That is all from me. The Harma reference. Thank you very much.
Thank you, Malina, for very insightful and interesting presentation. And now I will call the respondents, Ibu Fajar, Antoro, and Fatima, and then Dr. William Sulai. Time is yours. 5 minutes for yours.
Okay. Thank you, Mr. Chairman, for the opportunity given to us to respond to the brilliant presentations by Mr. Mahitra. I think I would like to first give the floor to Ms. Fatima in case she has any comments.
Okay, thank you very much for my partner. So for the presenter, as a respondent, we already appreciate for the author for the relevant analysis. So this research, we think that successful proof the existence of lenient attitude from the court. So my suggestion is that in the future could go deeper by investigating why the court behaved this way. So we think this study has done a good job of explaining what happened. So, but it will be stronger if also explain its causes. So, for the example, by examining the process of judicial appointment, so the background or the presence of political pressures. Additionally, so it will be very helpful if it backing or give a comparison in case of Madagascar with the other African countries. So to see if there is a unique case or a broader trend on. So finally, this research we think successfully identifies the existing problem and emphasize the importance of improvement. So the next is very useful is to give move from simply identifying the problem to offering the solutions. So in the future research, we hope it will be focused on proposing the concrete and suitable reform for Madagascar. And so for the instance, what legal could make the court more transparent and prevent it from hiding behind the procedural reasons only. So by providing practical solution, this research will make a real contribution and make it more strength of rule of law in Madagascar. And so maybe Mr. Bimo Fajar.
Okay, thank you, Ms. Fatima. I think the key points that the authors brought up during his presentation that is important for us to note is that especially how the executive dominance backed by the military and how Andry Rajoelina himself, being a popular demagogue, could force the Madagascar High Court into a judicial retreat, including how it treated President Rajoelina with impunity. I think, again, I don't want to comment on internal political issues, but I think it is important for us to reflect on our own experience in Indonesia, especially how the Indonesian Constitutional Court gave itself up to political pressures, especially during the eve of 2024 general elections, and how it actually deviated from the long-standing precedent of open legal policy by establishing an additional requirements for the presidential election candidacy. I think this shows how judicialization of politics and interbranch power grabbing are detrimental to the court's legitimacy. I think we could see how, for example, mass demonstration followed the decision number 19 of 2023. Well, if we look at how the text of Article 6, Paragraph 2 of our 1945 Constitution clearly stated that the text itself expressly delegates to the lawmakers the authority to add into the constitutional minimum stated in Article 6, Paragraph 1. However, rather than deferring to the lawmakers, the courts instead give way to political pressure. So this is very contrasting to what happened in Madagascar, especially how in Madagascar political pressures forced the court into a judicial pacifism or judicial retreat, and how in Indonesia it forces instead the court to become more activist, so to speak. And we all know how it ends up, especially in the context of Indonesia, where the Constitutional Court Ethics Council eventually found that there was severe ethical violations. And in addition, it is also important for us to note how Article 28D, Paragraph 1, which is frequently used as a basis for review in the Constitutional Court, becomes some sort of a Pandora box for the Constitutional Court justices to deviate from the constitutional text and to diminish the legislative authority of the lawmakers. I think there's several points that we want to point out. We would like to thank you, the presenters, for the brilliant presentation. Thank you very much. Thank you.
All right, thank you, Mr. Bimo Fajar Hantoro and Ms. Fatima Azhara for your great remarks, comment, and question. And now I would like to call Dr. Wilma Silalahi, please, you have 5 minutes to give a response for Karamalina. Yes.
Okay. Sorry. Thank you to Mr. Saru Arifin SLLM PhD. Thank you for the presentation by Mr. Ramalia Renova Mikea Manitra SH and Dr. Adi Paramita Prabmandari. And then thank you for participation and panitia. Sorry, in Indonesia. After this presentation, we present our arguments to Mr. Ramalia and Dr. Adia. I greatly appreciate both of your presentation. Sorry, I misread the paper. May I ask, does the public not trust the Constitutional Court to protect citizens' constitutional rights? The Constitutional Court also functions as a balance of power, enforcer of the Constitution and protector of the Constitution and democracy. As long furthermore, in my opinion, in the 1945 Constitution of the Republic Indonesia clearly states that the Constitutional Court upholds the Constitution, unlike other general courts which seemingly usurp the authority of other courts. Therefore, the Constitutional Court justification is not limited the criminalization, but rather to the establishment and or strengthening of a legal state of the creation of new legal relationship. A similar situation occurs in Germany. Furthermore, regarding the numbers demands from Indonesia legal expert for constitutional complaint to be regulation by Constitutional Court, we need amend the 1945 Constitutional of the Republic of Indonesia, because its power, duties, and other related matters and already stipulated in the 1945 Constitution. This do not mean that the Constitutional Court is not exclusive. In the Constitutional Court, even if a decision has permanent and binding legal force, it can still be resumed as long as the reason and passion differ from the initial position and position. As a final question, granting this authority to the state administrative court will not weaken the constitutional established authority of the Constitutional Court as the final interpreter of the 1945 Constitution. A state administrative justice are required to submit to the Constitutional Court interpretation if available and applicable. The Constitutional Court may not have this authority, but does the state administration court have the authority to so? Thank you, you PhD Saru Arifin, Mr. Bimo, and Dr. Adia, and Mrs. Fatima Azio. I'm sorry, I would like permission to attention the hearing, but I can join the meeting. Okay, thank you very much.
Thank you, Dr. Wilma, for your insightful comment and remarks. And Ramalina, you have a bit time to respond to all of respondents' comment and question. Time is yours.
Thank you very much. Okay. Thank you very much for the feedbacks from the respondents. I'm very grateful to what the feedbacks has been established, that indeed this research is considering more on what is happening. And I do agree with the feedback that it needs to understand also the reasoning behind those decisions. To be honest, the time was not enough to explain those reasoning behind the court decision, but I believe that the respondent have received the full paper, so it is more explained there as how the reasoning of the court was to legitimize the power of President Rajoelina. And one point that I think can be very valuable for Indonesia, as mentioned by one of the respondents, is that there was some issue as well, as I have lived in Indonesia for quite a long time actually, and I believe that I have got some lessons as well. You do consider ethical issue very important, even in constitutional court. And I believe that that would be some lesson for Madagascar to consider ethical issue as well, not only on the normativity of the constitution or the normativity of the decision, but also the ethical issue behind it. And that needs to be considered in Madagascar. That is all from me. Thank you very much.
Well, thank you very much, Mr. Ramalina Naifo, Pak Nitra, for your response for all the questions, remarks from the respondent. And I'm sorry, apologies for audience because we have exceeded 5 minutes from our schedule, so I cannot give you opportunity to ask questions for our speaker. But again, I would like to say thank you very much, especially first for his Excellency Professor Dr. Agnes Sin from the Constitutional Court of the Republic of Hungary for your time and insight for our conference. And the second one is thanks to Mr. Raul Guliev from the Constitutional Court of the Republic of Azerbaijan, and the last one is Mr. Ramalina Ranefo Mekia Manitra, and also all the responder or discussion for your time, discussion, and also comment to our speakers. And now the time I give to the Master of Ceremony. Thank you very much and see you.
Let's give big applause to speakers, chair, and respondents for session 2 of the 7 ICCIS. And now, ladies and gentlemen, I would like to invite our chair for session 3, Professor Muhammad Ali Safaat from Universitas Brawijaya, to guide and to invite all the speakers for session 3. Please.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen, and welcome to the third season of the 7th Indonesian Constitutional Court International Symposium. And now we meet by Zoom, and we directly going to the third session without the breaks because we are running out of time. And in this session, we have 3 speakers, and each speaker will be 2 respondents. The first speaker will be Tanto Lailam, LLM from Academy for European Human Rights Protection, University of Cologne, Germany. By the presentation will be a constitutional complaint on criminal and civil court judgment, the judicial practices of the Bundesverfassungsgericht and proposal for the Indonesian Constitutional Courts. And I think Tanto Lailam in his paper deeply compare between Constitutional Court of the Republic of Germany or Bundesverfassungsgericht, how the authorities, especially to review the decision of the ordinary court, both on criminal and civil judgment, and how this will be lesson learned for Indonesia Constitutional Court. And Tanto Lailam will have 15 minutes to give the presentation, and then followed by the respondent, Hikam Pulwanullah LLM and Tariq Abdul Aziz Wibowo, and also Associate Professor Farah Ahmed from University of Melbourne, and Dr. Jeffrey Purkananta Tarigan from the Constitutional Court of Indonesia. Tanto Lailam, time is yours within 15 minutes, please.
Okay, thank you, Prof. Safaat. Can you hear me?
Yes, clearly.
Okay, good. Can I share my PowerPoint?
I think so.
Okay, right. Okay. Okay, thank you very much, Professor Safaat, for this opportunity. Okay, I will share my research projects in Germany about the constitutional complaint on criminals and civil court judgment. The best judicial practices from Bundesverfassungsgericht and the proposal for the MKRI or Indonesian Constitutional Court. In Germany, I think okay, but it's very general. In Germany, there is one constitutional court in the federal level and 16 constitutional court in land level or provincial level. But Bundesverfassungsgericht or German Federal Constitutional Court, I think, is very independent and impartial judicial institution based on in Karlsruhe. Karlsruhe is a republic's this capital city of Baden-Baden or Baden-Württemberg, and this Bundesverfassungsgericht inaugurates in 1951. I think it's very 76th anniversary, and the Bundesverfassungsgericht is results from the policy of Bonn Constitution or 1949 Constitution of the Basic Law, and this one is I think it's very interesting. In 1952, the Bundesverfassungsgericht declared their Hüter der Verfassung or the guardian of the basic law, but it's very different than Hello?
Okay, please.
Oh, I think any noise. Okay. I think it's very different than Weimar Republics. I think there are debates on the guardian of the constitution between Schmidt and Hankelsen. And the winner of the debates, the Weimar debate is Carl Schmitt. And in Germany, I think the guardian of the constitution is not constitutional court, but the president, President Reich. There's expression from professor and scholar in Germany. I think Bundesverfassung Hungary is truly extraordinary power in Germany, an original institution, judicial institution in Germany, the guardian of the constitution, or the Hüter der Verfassung, or ultimate interpreter of the constitution, and developing of the constitutional democracy, and epicentrum of democracy in Germany. And from the newspaper, Professor Newspapers, the heart of republics. The Constitutional Court of Germany is the heart of the republic and authentic interpretation of the fundamental rights. And Jutta Limbach is the judges of the Constitutional Court of Germany. Like the Bundesverfassung Hungary is citizen court of par excellence. And from the president of Bundesverfassung Hungary, 2010 until 2020, Professor Andreas Vosulo, the Bundesverfassung Hungary is mediator between 1949's constitution, or the basic law, or German constitution, and European legal system and international legal system. Michaela Heilbrenners, a professor for Gießen University, has statement the positive counter model of Supreme Court of United States. And Johannes Messing, I think it's very good statesman, but the Bundesverfassung Hungary is many influence in constitutional court in the world. This point, judicial review power in Germany, I think is very clearly, but in Germany, in Bundesverfassung Hungary, they are the comprehensive power, the complete power of judicial review. Abstract judicial review, I think abstract judicial review is Hans Kelsen idea. Concrete constitutional review and constitutional complaint. Constitutional complaint is original practices in Bundesverfassung Hungary, not Hans Kelsen idea. The abstract judicial review focus on law in implication, in future implication, and concrete judicial review. I think you are known about constitutional question or judicial referrals. This mechanism is judicial referrals. But focus of concrete judicial review in the implementation of law in court cases or litigation cases. Constitutional complaints, I think, is focused on individual cases of violation about constitutional right and others. These ones, I think, is very the dynamics of regulation in Germany. The first time, the constitutional complaint regulated in Bundesverfassung Hungary law, not in the constitutions. In Bundesverfassung Hungary law, 1951, Article 13, you can see on this law, and then in 1969, amendments of the first constitution of Germany until last amended constitution in June 2022. The regulation of constitutional complaint based on the Article 93, paragraph 1, number 4A and 4B. And currently in Germany, the constitution last amended in March 2025, the regulation of constitutional complaints based on the Article 94, paragraph 1 and number 4A and 4B and 40. But is many model of constitutional complaint in Germany. The first, Article 94.A number 4A about individual constitutional complaints. And the second, Article 94, paragraph 1, number B, focus on city complaints or municipality complaints or association of municipal complaint, but provincial complaint in this mechanism, in these articles. And then Article number C, based on the constitutional complaints, municipalities based, but this case related the elections complaint, or announced election complaint in Germany. This type of the constitutional complaint proceeding in Germany, can you see my slides? Court decisions, law, other general object of legal challenges, other sovereigns acts and lands authority, other sovereigns act of highest federal authority, and many cases about sovereign act or European authorities. In the period between 2020 until 2024, in my research projects, the most cases constitutional complaint in the Republic of Hungary, I think you can see my slides, civil and criminal court is the highest cases, administrative courts, social court, and labor courts, finance and tax court, patents and constitutional court of 16 states. Yes, 16 states of constitutional court in the landers, in the provincials. The problem of ethics and problem of law by the lawyers, notaries, I think is very lower cases in Bundesrepublik Hungary. And then you can see my slides. This is a statistic of statistical constitutional complaint on the federal, on the civil, on the criminal and civil court judgment. You can see my slides. These cases, the highest cases is civil court, and the second cases is criminal court. But you can see my slide, the start 1 and 2 and 3, new proceeding, but the star 1 is new proceedings, decision and successful application. And then this statistic of cases, constitutional complaints on the Supreme Court cases. The first Federal Court of Justice is very highest. I think in 2024 their cases is more than 300, but the successful application is very zero. You can see my slides, James. And this one is very good landmark decision in Germany, Lut case. Lut case is object of this Lut case is civil court of Hamburg decision. Lut case is constitutional complaint by decided by the first Senate in Germany, but in Germany there are 2 senates, each judges in first Senate and each judges in second Senate. The problem of Lut case, I think, is very constitutional conflict between business or economic interest with the freedom of expression in Germany. Lut is a matter on the free of Hamburg and the state of press office, and his capacity of president of Hamburg Press Clubs gave a speech into the film distributor and director of opening the German Film Weeks. In his speech, Lutz proposed a boycott Harlan film. Harlan film is, I think, Harlan film als stijlblige geliefde. I think it's very negative morality. You can see my slides, the petition and the decision. The Bundesversammlung judgment state that Hamburg Civil Court was the contrary the basic law, and the action were a firm freedom of expression and speech. The contrary with the Article 5, Paragraph 1, every person shall have the rights freely to express and disseminate his opinion in speech, writing, picture, and inform himself without accessibility source in media mainstream or in social media. The second case, the soldier model of case, this is a hate speech case. is very different in Indonesia. Hate speech in German, I think, include in freedom of expression. Object dispute, criminal court judgment, and the Solid Model is constitutional complaint case decided by the first Senate of the Bundesrat Hungary. The judgment states that the criminal court decisions are contrary to the Constitution, contrary to 1949 Constitution or German Basic Law, specifically Article 5, Paragraph 1 of the Constitution. And applicant action or where the form freedom of expression based on this article. That's the basic law. But this one is proposal for redesign of the constitutional complaint or judicial review system in the MKRI based on the Bundesrat experience. I think you are see in my slides the President of Mahkamah Konstitusi Republik Indonesia, Mr. Hamdan Sulfa, state the constitutional review models of both Bundesrat Hungary and MKRI is identical and is based on European model of constitutional review. Constitutional review, I think, is term from Europeans, and judicial review, I think, is judicial term from U.S. Supreme Court. And then in legal tradition, Indonesian and German, I think, it's civil laws traditions. And from the justice of the MKRI, Professor Idewa Gede Palguna, I think it's very good. It's very interesting for the redesign of the Constitutional Court Indonesia. Can you see my slides? The constitutional complaint constitutes a component of constitutional review, but many problems about the decision of the Constitutional Court rejected applicants about how to edit MKRI function about constitutional question and constitutional complaints in Indonesia. Legal reasons why redesigns of constitutional complaint on judicial review in Indonesia, I think it's the misunderstandings about pengujian undang-undang. Pengujian undang-undang in MKRI law focus on abstract judicial review, but that's not included in concrete review and constitutional complaints. I think it's not clear in Indonesia. It's very different than Germany. Abstract judicial review, concrete judicial review, and constitutional based on the different article in the basic law. The design of judicial review in Indonesia has been not able to provide comprehensive protection of citizen constitutional rights. And then legal consequences of MKRI, I think it's many weak legal cultures, constitutional disobedience, the problem of contradiction between decision, and many cases about constitutional ethics, the problem of the constitutional ethics violation in the judges in German in the MKRI. This proposal for the constitutional complaint in Indonesia, object of disputes, many cases applied to the MKRI, but the power constitutional complaints focus on ordinary court judgment that have been legally enforcement or criminal judgment, civil court judgment, administrative and military and religious judgment. I think includes object of dispute in this case, MPR decree, misinterpretation of Article 1945 Constitution by the state institution, violation of constitutional rights to the conflict of law, and ethic board decision. Applicants is very different in Indonesia and Germany. In Germany, foreign citizens can apply many legal challenges or mechanism, judicial review, constitutional complaint, abstract judicial review, concrete judicial review. And then implementation, the final judgment in general court must be reopened. and court's concern must be decided based on the MKRI decision. This one is very interesting. In Germany, I think many financial compensation for procedural costs, not demands by the applicant, but for the procedural cost. And then legal policy, I think the fifth amendment of the Constitution is very clearly, and if we are refer based on the Bundesverfassung Hungary or German Constitution or German's practices, the revision of the MKRI law, I think is very interesting, but I think it's impossible. It's very impossible. I think it's enough, Professor Safa. Thank you very much for your timings.
Thank you, Tanto Lailam, for the comprehensive presentation and rigid with a lot of data. I think it's very interesting. I wonder how many percent of the ordinary court decision that apply to the constitutional complaint in Germany. And we invite the respondent, first of all, Hikam Hulwanullah LLM. Please give the response for the Tanto Lailam presentation within 5 minutes. Time is yours.
Thank you, Prof. Ali. Could you hear me clear, Prof?
Yes, clear.
Okay, by the way, first of all, congratulations for Prof. Tanto Lailam for the presentations. It's so nice presentations. As a constitutional law lecturer, scholar, I view this article as a significant academic contributions to the ongoing discourses pending the jurisdictions of the Constitutional Court of the Republic of Indonesia through the adoptions of the constitutional complaint and judicial review on the court judgment mechanism as a practice by Germany's BVRFG. But in my humble opinion, I conduct my master's research in the field of the constitutional right, where Prof. Ali Safat is my supervisor in Brawijaya University when I took my master's program. So when we talk about the constitutional complaint, where Germany serves as one of the best examples in the implementations of the constitutional complaints, one notable case is when the German Supreme Court ruled the practice of slaughtering cattle by Muslims during Eid al-Adha violated animal rights. However, these decisions conflicted with the constitutional rights to freedom of religion for German citizens. As a result, and as we know that the German Constitutional Court letter and then a rule, the decisions was unconstitutional decisions by the High Court of the German. My specific suggestions or critics about these papers. First, the paper normatively proposed the Indonesia's Constitutional Court mechanism by German. So it compares the German systems. However, Professor, it does not sufficiently explain whether such a model can be effectively transplanted into Indonesia's legal and judicial systems, which is rooted in civil law administrative state traditions. Let's say Indonesia's legal system upholds the principle of finality of judgment and the prohibitions of ultra petita when we know that how does the author address the potential conflict if the Constitutional Court is later empowered to annul final and binding judgment of the Supreme or ordinary court. Second one, has the author considered the path dependency of Indonesia's judiciary, which has evolved under different historical, political, and cultural conditions compared to Germany? And then the paper could be strengthened by maybe applying normative constitutional theories by Alexei Grimm and so on. In methodological, I think it's so good because it tries to compare with the comparative method, but the problems is the boundaries of the comparations remain unclear. So is it the comparations normative or functional? And then for the implications, that's the highlight. Is it possible to implement the conditions when Indonesia in high court, it is a final and binding. When we try to review by the constitutional court, as we know, it will be a problem. So it is maybe a challenging for the research in the future. I mean, like for the next research about this idea. But I think overall it's a good, and I believe that it will be milestones research in the constitutional complaint. Thank you very much, Prof. Ali Safaat.
Okay, thank you very much. Very good question about how we apply such comparison with the Germany to Indonesia. It's not only because the Germany is very good, the decision of the Bundesverfassungsgericht, but also we have to look to the Indonesian condition, whether it's the same trajectory or not. Second, I invite Dr. Jeffrey Porkonanta Tarigan to give a response, please.
Okay, thank you, Professor. Can you hear my voice, Professor?
Yes, clearly.
Okay. Good afternoon, Honorable Chair of the session, Professor Ali Safaat, distinguished speakers, respected respondents, and participants of the 7th Indonesian Constitutional Court International Symposium. It's an honor for me to join this important forum organized by International Indonesian Constitutional Court, which discuss about constitutional justice and judicial reform. I would like to express my appreciation to Mr. Tanto Lailam as speaker for his insightful paper that combines theory, comparison law, data, case examples with comprehensive explanation. In this short response, I will share my views on the key points of his paper for Indonesian constitutional system. This article describes about how the German Federal Constitutional Court, Bundesverfassungsgericht, sorry if I won't.
Bundesverfassungsgericht.
Yeah. That enforces judicial review on criminal and civil court judgments. That's interesting. Mr. Lailam proposes that Indonesia's constitutional court could adopt a similar approach. The goal is to strengthen constitutional protection for the citizens when their rights are ignored by court decision, not only by legislation. The Bundesverfassungsgericht is an independent and highly influential constitutional court in Germany. If I conclude based on Mr. Lailam's presentation, the Bundesverfassungsgericht has three main types of judicial review in Germany. First, abstract review, and then concrete review, and last, constitutional complaint. Yeah, Mr. Lailam have been described about the authority and the types of judicial review in Germany. From this paper, from Mr. Lailam papers, we can see that about 80% of the German Federal Constitutional Court's cases come from constitutional complaints. Yeah, it shows that the court have a crucial role in protecting citizens' rights. And this paper has good illustration, I think, because it explains with clear examples the branches of judicial authority in both civil and criminal courts. Mr. Lailam described at least two cases can be considered as landmark decision. The Lut case in 1958 and the soldiers are murderers case in 1995. So what can we learn from the German system for Indonesia? I think, yeah, in Indonesia we know the Constitutional Court, we call it Mahkamah Konstitusi, currently reviews only laws or undang-undang against the Constitution, Undang-Undang Dasar 1945. And then Mr. Lailam proposes expanding the Mahkamah Konstitusi's Mahkamah Konstitusi's power to allow judicial review of court decisions that ignore constitutional rights. This idea would make the Mahkamah Konstitusi a stronger guardian of citizen rights and create better checks and balances within Indonesia's judicial system. The German model shows that allowing constitutional complaints against court judgments is an effective way to protect fundamental rights. If adopted correctly, this idea would improve Indonesian system of constitutional justice, but Indonesia might face institutional and procedural challenges in adopting the German model, such as overlapping authority with the Supreme Court or Mahkamah Agung, issues of judicial independence, and caseload management. So my question is, how to coordinate between Mahkamah Konstitusi or Constitutional Court and Supreme Court or Mahkamah Agung to handle the case, especially civil and criminal case in Indonesia. Are we need to increase the number of Constitutional Court judges or consider ad hoc judges, perhaps, maybe, that focus on criminal and civil court judgment. Yeah, however, the implementation must consider it must consider the judicial structure and Indonesian legal diversity and Indonesian legal system. Like, we have civil law, Islamic law, customary law, or adat law. Yeah. So it can be challenges for Indonesia to adopt a German system. Yeah. Thank you, Professor. Maybe that's all for me. Thank you very much, Professor Ali Safaat, the chair of this. Thank you.
Thank you, Dr. Jeffrey. And I invite maybe from the other attendant in this Zoom ask the question 1 or 2 minutes. Now, and I invite for the next session for the next speaker, if the participant wants to ask or comment 1 or 2 minutes, please raise your hands. I mean, not your physical hand, but the emoticon hands. Okay, and I give times to Tanto Lailam to respond the responders, some question and also some comments. Please.
Thank you, Mr. Hikam and Mr. for your good comment. It's very different, Indonesia and Germany, Professor Safaat. Indonesia is many cases on abstract judicial review. In Germany, 1 until 3 cases abstract judicial review in Germany. But only once until 3 cases abstract judicial review in Germany. Concrete judicial review, I think 30 until 40 cases in Germany per year annually. And constitutional complaints, I think more than 5,000 cases per year. That is very, I think for 98% cases is characteristic of constitutional complaint in Germany. Okay, many cases about interesting in Germany, but I think Mas Hikams mentioned about Islamic jurisprudence. My professors, Professor Angelicus Becker, state that many Islamic jurisprudence in Bundesrepublik Hungary, in Belgium, in the European Court, mention Islamic law or Islamic jurisprudence. Headscrap cases and legal trial cases, I think, related the freedom of expression in Islam, but I think next time we are discuss about that. Ultra petita, I think Bundesverfassung Hungary is many cases about ultra petita, and but the model of ultra petita, I think, related the model of decision incompatible cases or incompatible decision. Incompatible, I think, the legislator have times to revise the acts or to end the constitutional, the ordinary court, Supreme Court or Federal Court have a time to revise the decision. And then brothers Jeffrey, I think, what is the problem or model of discussion, Supreme Court and Mahkamah Federal German or Bundesverfassung Gericht. In Germany, there's mechanism of judicial dialogues between judges in Bundesverfassung Gericht, between the judges in human rights, European human rights, and judges in Supreme Court or Federal Court of Justice in Germany. I think it's very good model of judicial dialogues in Germany. But next time I will write about judicial dialogues model in Germany. But this Prof. Sapat, I have the points of procedural judicial review or constitutional complaint in Germany. In Germany, this process of constitutional complaint without oral meetings, and this process, I think, once month is clearly, only 1 month is very clearly, and the applicant is very easy to write apply of the applicant's points, but it's very easy to apply constitutional complaint in Germany without lawyers and professor in the university. But I think public is very good experience how to apply constitutional complaint in Germany. And then many foreign citizens from Nepal, from India, apply a constitutional complaint in Germany. But it's very different in Indonesia. Only warga negara Indonesia, only Indonesian citizen. And then, yes, this point is without oral meeting in the constitutional complaint processes. Thank you very much, Professor Safaat.
Okay, thank you very much, Tante Lailam, Hikam Huanullah, and Jeffrey Purwalda for warm discussion the constitutional complaint, especially when we compare to the Germany. Thank you very much again, and we end this not this session, but these speaker groups, and we move to next speaker. Will be Pak Reza Saputra from University of Pembangunan Nasional Veteran Jakarta, Indonesia, will present concerning civil society as constitutional guardian, comparative analysis, and Indonesian prospect. This presentation will be about the role of the civil society organization, I think, and compare with the constitutional complaint in South Korea and South Africa. And the respondent will be Jane Natasha and Nisrina Mumpuni Auri Kinasih from University of Airlangga, and Anak Agung Dian Onita from Constitutional Court of Indonesia. And without further ado, I give time to Reza Saputra to give the presentation within 15 minutes. Please, time is yours. Halo, Reza Sapitra.
Please welcome our speakers of the 7th Indonesian Constitutional Court International Symposium. His Excellency, Professor Dr. Idewa Gede Palguna. His Excellency, Kadir Oskaya. His Excellency, Nopadon Tepitak. Her Excellency, Catherine Mary Savage. His Excellency, Rauf Guliev, Miss Sabina Mirsayeva, Miss Arzu Alieva. Her Excellency, Professor Dr. Agnes Chini. Mr. Nikita Iyunov, PhD. Jane Natasha, Miss Rina Mumpuni Eurikinasi. Ramalina Ranaivo Mikea Manitra SH, Dr. Adia Paramita Prabandari. Tanto Layam LLM. M. Reza Saputra SH. Thomas Sekumara. Murti Ayu Hapsari MH. Bimo Fajar Hantoro SH LLM. Fatimah Az-Zahro MH. Tria Noviantika MH. Andia Musfira SHMH, Rilo Pamudi SMH, Dr. Sugeng MH, Dr. Ervina Fuadatul Hilmi, Fitri Maulidiah SH, Hikam Hunwanullah LLM, Torik Abdul Aziz Wibowo MH, Associate Professor Farah Ahmed.
Okay. Due to technical condition, the speaker of the session, the 8 speakers, it's not already in the Zoom. So we move to the 9th speaker, Thomas Sekumara from Nusa Putra University, Sukabumi, Indonesia. Will present the judicial independence and the effectiveness of constitutional complaint system. I think it's also compare the constitutional court in Germany and South Korea and in Indonesia. And the respondent will be Tanto Lailam, LLM, and Dr. Mary Christian Putri, SIMH, from Constitutional Court of Indonesia. So please, I invite Thomas Sekumara to give the presentation concerning judicial independence and the effectiveness of constitutional complaint system within 15 minutes. Please, time is yours.
Okay, give me a minute, please. Let me just share my...
Okay, takes your time.
Okay, can you see my screen?
Yeah, we can see.
And my presentation.
Yeah.
Okay, good afternoon, distinguished justice colleagues, professors, and students. It is a great privilege to present at the 7th Indonesian Constitutional Court International Symposium. My presentation is titled Judicial Independence and the Effectiveness of Constitutional Complaint System. This subject of constitutional complaints may sound technical, but at its core, it is about something very simple. How can citizens directly defend their rights when they believe their state has violated them? If you are with us this morning, we have been hearing a lot of speakers, professors, and academic fellows talking about the same thing and explaining about the constitutional complaint system. In this presentation, I will show the answer depends on one decisive factor: judicial independence. Without independence, complaint system collapse. With independence, they can protect democracy. And I will also like to note that I will draw lessons from Germany, South Korea, and Italy, and reflect on the challenges and opportunities for Indonesia. Next slide. Okay. So, constitutional complaints in modern democracies, constitutional complaints plays a very critical role because it allows individuals to actually challenge the laws, policies, or administrative actions that infringe upon their political or fundamental rights. So this is simply mean that unlike judicial review triggered by institution, judicial constitutional complaint system actually empower individuals. So in the layman term, I may want to simplify this. Constitutional complaints are mechanisms that allow individual citizens to get directly to the court or to the constitutional court when they feel their rights have been violated. Let us think of it this way. Imagine you as an ordinary citizen, you are not a politician, or you are not a member of parliament either, and you feel a government regulation has violated your rights. Without a constitutional complaint system, you may have no direct way to challenge it. And if we take a look at countries that have such systems, like Germany. In Germany, Germany gives every citizen a pathway to the highest constitutional authority. As the last speaker was mentioning about Germany, I don't know the key term in Germany, but it's really hard for me. This is very important because rights are not protected only in theory. They must be accessible in practice. We must see them not only in book. It must reflect daily practices. However, this process only works if the court is independent from any politics and if the court is a separate branch of government. Judiciary must be judiciary, executive must be executive, and legislative must be legislative. If judges are influenced by politics or lack of resources, complaints will not be decided fairly. I believe everyone agrees with me. So as you can see, this diagram illustrates that it illustrates the pathway: citizen, courts, and rights protection. But when independence is weak, this path break. Next slide would be research objective. So my research 4 main objectives. Firstly is to examine the link between judicial independence and complaint effectiveness. This is not just a legal theory, but something visible in practice. Secondly, it conducts a comparative study between Germany, South Korea, Italy, and Indonesia. These countries offer different level of independence and with different results. So thirdly, I will identify why Indonesia does not yet have a viable, underline the word viable, complaints mechanism, and what barriers stand in the way. And finally, to propose reforms that could make the system work here in Indonesia. So my aim is to offer a very practical, evidence-based recommendations, not only theory. Next slide. Okay. So yeah, to approach these questions, I used comparative doctrinal research, which means I actually studied some parts of the Constitution, not all, and I also studied court rulings, statutes, and also international reports from the United Nations and the Venice Commission. So yeah, this analysis was guided by 4 main pillars. As you can see on the screen here, focus. So access to justice. In any of these 4 main pillars, I will ask a question if whether you are saying these theories reflect. Number 1 is access to justice. Do Indonesian citizens actually reach out to the courts? That is one question I want you to ponder upon. 2 is judicial independence. Do judges decide interference or without any political or some external interference when they want to judge a case? And 3, we have got procedural safeguards. Are the rules in Indonesia clear and fair? As one time my professor, I was taking a professor's class from Italy, Professor Marco, stressed out that for a law to be effective in any society, it must be unambiguous, which means the law must be clear no contradictory statement, and it must reflect to the society need. That is why the court got some issues with the Indonesia omnibus laws. And also civil society. Do NGOs and advocacy groups play a role in Indonesia? So yeah, these four pillars together determine whether a complaint system is really effective. So this, I don't know if you can see the diagram also. This shows shows how they connect. Like all four pillars support the roof of effectiveness. As you can see, effectiveness is up here. And also right to justice and procedural safeguards are down, supporting one pillar, which is effectiveness. So if one pillar collapses, the whole system risks collapsing. If there is no right to justice, civil society will be scared to speak out. Example like political activists, youth activists, etc., because they would be put behind bars. Okay, let's say, for example, in South Korea, civil society plays a big role in making the system accessible to the vulnerable groups. In Germany, procedural safeguards filter cases. So if you wonder if whether a constitutional complaint system, while I was attending and listening to some respondents, I got to hear that if complaint system could like backlogs could really increase backlogs in the Constitutional Court of Indonesia. But actually, I know everyone wants to complain, like their rights have been violated by the government, more especially people or citizens that are not in favor of the incumbent or the current government. Every little mistake, they might want to file a complaint to the Constitutional Court, and which may really lead to a huge amount of works and backlogs in the Constitution. But actually, in Germany, the procedural safeguards filter cases, like they filter cases by admissibility. If whether this complaint really reach or satisfy the admissibility we are looking for, if yes, then the court may proceed. If no, they might strike it down. And also in Italy, judicial independence allows the judges to use discretion. Like this example shows that no single pillar is really enough. They all must work together. And I'm going to the comparative analysis of Germany. I don't know if comparative. Okay, can you see my screen? Yeah, so let us begin with Germany. The German Federal Constitution Court is often described as the gold standard of the constitutional complaint system. Like any citizen can file a complaint. Independence of judges is strongly protected by law and tradition. The court enjoys high public trust. Let's say, for example, one of Germany's landmark cases involved restriction on free speech. A citizen challenged the law directly at the Constitutional Court of Germany. And you know what? The court struck it down. The court affirms free speech as a constitutional right, not as a privilege, but as your own right as a citizen. Not like the current president of the United States, which is really driving the Constitutional Court of USA to a privilege instead of a right. But it actually applies to foreigners or third parties. So why does this work, if you ever wondered? Because the court is really independent. No political party, no government, ministers, honorable can actually dictate the outcome of any case. This shows that when independence is guaranteed, even politically sensitive cases can be resolved fairly And the next one is South Korea. Okay. So in South Korea, the constitutional complaint system is integrated into the constitutional courts, like directly. So what makes it more unique from others, like Italy, Germany? What makes it more unique is its focus on vulnerable groups. Let's say, for instance, if a law proportionately arms students, women, or let's say minorities, individuals can file a complaint and the court must respond promptly, like swiftly. You know what? Because the court is relatively independent. The public sees it as a fair institution. This has built confidence in democracy. Not like in Indonesia. Actually, I don't have the statistics or a data, but while I was interviewing some, like usually I used to take a Gojek, some people usually complain about the constitutional court and the government. Like there is usually a high impact of political influence when deciding cases. And just like the Professor Dr. Dewa Gede, the former constitutional justice, said that it is ideally possible to really adopt a constitutional complaint system, but politically impossible. Then when I heard that, I reflect from one case studies I encountered while taking a Gojek in Malang. So let's take a good example in South Korea. Like one landmark cases or ruling is on students' rights. It's demonstrated that the judiciary could protect the weaker sections of society, even against powerful state interests. So this model teaches us that the model teaches us the value of timeliness and also fairness. A complaint system must not only exist, but also respond quickly and effectively. And the next one is Italy. Okay. So Italy offers a very fascinating balance. Its court uses a procedural formalism, like strict rules. The laws are very strict, but it also allows judicial discretion. So this means that the courts in Italy can adapt to a new social or legal development. As we all know, the world is increasingly growing in technology. So let's say, for example, when new technology raises privacy concerns, the courts can interpret constitutional principles flexibly, no matter how rigid it is. So the Italian model shows us that rules and discretion are not enemies at all. Instead, when exercised independently, discretion strengthens the court's legitimacy. But as it stands now, if the Constitutional Court of Indonesia get to decide any case based on their own opinion or based on the current situation in the world, I believe 90% of the citizens will say it is a corrupt judge. And that's what I hear the most. But actually in Italy, discretion is allowed. A judge can judge based on his opinion, based on the current situation. But I know the reason why most Indonesians would not agree to any judge who really judge a case based on his own opinion because of the current situation. It's because the court lack independence. Some cases are politically decided. So with this, there is no legitimacy at all, and the citizens cannot be able to really see the Constitutional Court as a fair institution. So yeah, the lesson here is very simple from the Italian model. It's very, very simple. independence plus flexibility is equal to resilience. So the courts that can adapt, maintain public trust, while also protecting rights. So we go to Indonesia. Okay. So the Constitutional Court, as I made mention, in Indonesia has a very strong powers in judicial review of laws and resolving disputes between the state organs. But there is a missing element though. Individuals cannot file constitutional complaints directly. This means that if a citizen believes a government regulation violates their rights, there is no direct route to constitutional justice. So on top of this, there are also challenges like political influence. Sometimes it affects judicial decisions, and lack of resources also slow down case processing. And lastly, low public awareness. When I was doing my KKN, I'm actually in semester 5. While I was doing my KKN in Gunung Tanjung, a place which made me to really ask if there is a politician in this place, because the road was so bad and they had no access to they had no access to anyone to really teach them about their rights. And I had the internet problem, so on. So low public awareness, like places in Gunung Tanjung, does not know what legal remedies exist. So one of the main challenges in Indonesia today is low public awareness. Like many citizens don't even know what remedies exist. So this gap creates a frustration. So imagine being a villager affected by a discriminatory local regulations. You cannot directly approach the Constitutional Court. That is what I call a democratic deficit. So next, okay. So I meant to understand that judicial independence is the central condition and is the ultimate goals every democratic country should adopt. Because where independence is strong, like Germany, South Korea, complaints are really effective and citizens trust the system, like they trust the process. But where independence is weak, complaints are absent and complaints are delayed or complaints are politically influenced. So without independence, constitutional complaint system become like an empty promises. With independence, they become a powerful guardians of rights. So next recommendations. Okay. So actually, what should Indonesians do? I did propose 5 reforms. One, I proposed that Indonesians could establish direct visual access to constitutional complaints. 2, they can strengthen the judicial independence in all dimensions: structural, functional, financial, and also administrative. And 3, simplify procedures so ordinary citizens in like places in Gunung Tanjung can actually able to navigate them. And 5, use technology, online filing, case tracking, and also open access to decisions could also play a role as the internet is increasing and the world is increasingly with technology. Like these are the 5 steps. These 5 steps taken together would really transform Indonesian constitutional court into a true guardian of rights. Let's say, for example, Germany filters complaints through admissibility checks, as I made mention earlier. Indonesia could do the same. South Korea quick rulings for minority groups or vulnerable groups could inspire special fast-track procedures. And also, Italy's balance of rules and discretion could really help Indonesia maintain flexibility while ensuring accountability. But I could always suggest Indonesia to use the Italian model if only there is constitutional complaint system and a public trust. So yeah, in conclusion, constitutional complaints are more than legal procedures. Everyone can agree with me. They are democratic safeguards. Their effect depends not just on the law, but on the practical independence of the judiciary. So Indonesia has a historic opportunity to learn from comparative models by establishing direct access, ensuring independence, simplifying procedures, engage society, and embracing technology. Indonesia can build a system that both protects rights and also strengthens public trust. So ultimately, a constitutional complaint system is not just about law. It is about the people, you and me. It's that the ordinary citizens, not just the powerful, has a voice in constitutional justice. And I'm sure that's what the Constitutional Court is doing now by making a wonderful symposium like this. So thank you very much, and I'm looking forward to your questions.
Thank you, Thomas Sekumara, for your presentation. And we move to the respondent. First, Tanto Lailam, LLM, and then Dr. Mary Christian Putri. I give time to Tanto Lailam to give response to Thomas' presentation within 5 minutes, please. Tanto.
Our lady first, my colleague Mbak Mary.
That's okay. Mary, are you ready?
Sure. Thank you so much,
Yes.
Tanto. Good afternoon,
Yeah.
distinguished speaker. Thomas, should I say Marah or Merah? Okay, then let me just call you Thomas. It's another privilege to give the second command for today. You already wrote a very insightful paper. It provides a very thoughtful contribution to our ongoing dialogue on strengthening Indonesia's constitutional framework and advancing access to justice. I can say that your paper has offered a compelling argument that the true strength of any constitutional democracy lies not only in the text of its constitution itself, but also in the independence and integrity of those entrusted to defend and divine it. But then to reflect on this paper, I would like to offer some or few additional thoughts. First, while you mentioned that structural reforms are very crucial, actually cultural transformation within the judiciary is also equally vital. Judicial independence must become a shared professional ethic embraced by the judges or justices, supported by the government, but also understood by society. And then the second, safeguards against judicial overreach. The safeguard against judicial overreach should accompany the independence itself. So an empowered judiciary must remain transparent and accountable to constitutional principles. It should be also keep in mind that these proposals are not merely technical, but they are also deeply moral. They affirm that justice must be accessible, impartial, and responsive to the needs of the people. They also remind us that a court's legitimacy is measured not only by its decision, by the public's trust in its independence. Well, it raises the two critical questions arise from your comparative and analytical insights developed in your study. The first, how can Indonesia effectively balance the judicial independence with accountability in establishing a constitutional complaint mechanism? As you also already mentioned that Indonesia hasn't had the direct mechanism for this constitutional complaint mechanism. So then how should it balance? And then the second, what role can civil society and digital innovation jointly play in improving accessibility and efficiency within Indonesia's prospective constitutional complaint system? As I can suggest, probably civil society organizations, when it is empowered through technology, could possibly act as intermediaries between citizens and the judiciary. It could provide legal assistance, promoting awareness of rights, and facilitating transparency. Integrating those kind of digital platforms such as electronic filing systems that is already implemented by Indonesia's constitutional court, and then online complaint tracing and public access to judicial decisions can democratize justice by minimizing the procedural barriers. Well, future studies should examine how this synergy between civic engagement and technology can be institutionalized within Indonesia's constitutional framework, while ensuring the data security, inclusivity, particularly for the marginalized communities. I think that's all from me. Congratulations, Thomas. It was a very insightful and also thoughtful paper. I give the time to chairs. Thank you.
Thank you. And next, I give time to Tante Lailam to give response within 5 minutes. And for other participants, if you have a question or other, maybe you raise the emoticon hand right now. Please, Tanto.
Okay, thank you, Prof. Pats. I think it's very interesting articles by Thomas, but I'm so sorry, Thomas. I'm focused on German's experience, German regulation, and German constitutional complaint practices. The independency or impartiality related to effectiveness of constitutional complaint. I'm so sorry, but there's mechanism of constitutional complaint in Germany. The first, individual constitutional complaints. The second, city or municipalities and association of municipalities constitutional complaints, and election complaints. The first, individual complaint, focus on the competing rights between individual and individuals, or between the individuals and economic interests, or between the individual and social organization interests, but not conflict or constitutional conflict individual interests. Between individual, not only individual interests and political interests. It's very different that you analyze about the elections complaints. Election complaint focus on the problem of election, the problem of democracy, the problem of election law in Germany. But if you analyze about individual constitutional complaint, you can analyze about the protection of human rights or the protection of fundamental rights just only. That's I think not related the democracy and rule of law system, but the rule of law system is very different if you just analyze about the individual constitutional complaint. The second spot, I think, is independent and impartiality of the constitutional justice is very interesting, but the key of fair and justice and judiciary. The independent and impartiality of justice, I think, is mainly influenced by the designs of the constitutional organs, structures, legal cultures, democratic models, human rights guarantee models, and access to judiciary mechanism. You say that German is strong judicial independence, but it's different criteria, Indonesia, Italy, and Germany. I think strong and weak judicial independence regarding effectiveness of constitutional complaints. I think you can analyze their rigid criteria, not only in regulation, but behavior case in justice. In justice behaviors. I think there are 4 criteria about strong and weak judicial independence. The first, related to the institutional design factor of the court, the authority, recruitments, supervisions, and political and legal culture. I think in Indonesia, yes, weak legal culture and weak political cultures. The second point, you can analyze the internal factor of the judges, or constitutional reasonings, dissenting opinions, concurring opinions, and the next points related to the personal factor of the judges, credibility, intellectuality, accountability, legal knowledge, integrity, ethics, and the fourth points, the problem from law professor, the public organization, and I think many criteria related to judicial independence in the constitutional complaints, but the judicial in the perspective of judicial independent legal theory, I think seems Indonesia, Germany, Italy, but if you analyze about judicial independence in the perspective of ethical violation or constitutional ethics is very different. I think many weak judicial independence and impartiality with the credibility, intellectual accountability, morality, and yes, impartiality and capability, equality of the personal justice with leadership and others. But I have research about the collapse of Indonesian Constitutional Court in perspective of constitutional ethics in Indonesia, but not perspective in judicial independence in legal theory framework in global perspective. The criteria in my research, I found many cases about judicial ethics or ethical violation by the judges in Indonesia. The principle of propriety, integrity, independency, impartiality, equality, and competence and competencies. But I think it's very different if you compare Germany, Italy, and Indonesia based on the general judicial independence. But you can focus on specific case in the first specific case in individual constitutional complaint or election complaint in your article. But the second point related to judicial independence in you must clearly judicial independence in legal theory in the global perspective, or judicial independence in perspective of constitutional ethics, like in Indonesian's problems. I think that's all, Professor Safaat. Thank you very much.
Okay, thank you very much, Tantu Lailam. And I give 5 minutes the speaker to Thomas Sekumara to give feedbacks, please and directly to the response from the respondent. Please, thanks yours. I think you still mute position.
Can you hear me?
Yeah, it's clear. Okay.
Okay. As far as I can understand, thank you very much, Prof. Mary, Professor Marys. That was the name I can able to pick up. And I was able to get only the last question about the technology or some other aspect related to technologies. So, like in Indonesia can strengthen its constitutional complaints framework through gradual structured approach. Like the first is to provide access, like direct access for individuals to file complaints before the constitutional courts. This would not require a constitutional overhaul, only procedural regulations to allow individuals standing before the court. Second, procedural simplification is essential. The complaints process must be understandable, even to citizens without legal training. Thirdly, the judiciary must reinforce institutional independence in appointment, budgeting, and case management, so that every complaint is handled impartially. And finally, by engaging civil society and legal education related to technology, they can actually create a website or use social media awareness to teach citizens about their rights and duties also, or obligations as a citizens. So you were talking about technology. It can really be a game changer. Like a digital complaint can make constitutional justice more accessible, transparent, and also efficient. Let's say, for example, online filing portals can allow citizens, even in remote areas like Pelebo and Ratu, or like Penyuan, Malang, or Bromo places, to submit a complaint without traveling to Jakarta, because these places are so far. From there to the constitutional court, it may cost them a ample of time and a hefty amount of money. So yeah, digital tracking systems can really show the status of the case, ensuring transparency and also accountability. One key thing, we have got artificial intelligence tools that can even help filter admissibility or check completeness of documents before submission. Like I mentioned, in Germany and South Korea, online databases make constitutional decisions public, strengthening civic trust. So Indonesia could really adopt similar digital integration to make the constitutional court more open and citizen-friendly. So yeah, technology therefore bridges the gap between the people and the constitution. So to Mr. Tantes, you were talking about the independence or impartiality related to the effectiveness of constitutional complaints in Germany, and why Germany is why Germany is the best, because you made mention of like it has a lot of criteria, and why I compare with Indonesia. So I would like to say thank you. Thank you very much for that insight. And thank you also for your comments. This may help me in further research. So I would like to stress that Germany is often called the gold standard or the best, because it fulfills all 4 dimensions of judicial independence, like the structural, functional, financial, and also administrative. Structurally, judges are appointed through a balance. You can agree with me with that. And a transparent process that prevents political domination. So functionally, they are free from any external instruction. No minister or parliament can influence a decision. And I guess you can also agree with me to that. So financially, the court has its own budget approved by parliament, ensuring that no executive control administratively. It manages its own staff and internal rules, like it's really independent. Because of this, Germany's constitutional court enjoys exceptional public trust and compliance. Citizens believe that every case, regardless of political sensitivity, will be judged impartially. So if I am to contrast, like if I were to contrast it to Indonesian Constitutional Court, it has independence, but struggles with functional and financial autonomy, like political influence in appointment, limited resources, and also executive dependence weaken its impartiality. So Germany's effectiveness comes from independence in practice. Indonesian challenge is to translate constitutional ideals into operational reality. And you ask, why did I compare like Germany, Italy, and Indonesia? So I would really like to say that is an important question. And why? Because I compared Italy and Indonesia because they represent different stages and traditions of constitutional complaint evolution. Germany represents a mature model, a very, very mature model. I call it a gold standard, a fully institutionalized complaint system with high independence and accessibility. Italy represents a hybrid model, and that's what I love the most. Formal procedures combined with judicial discretion, balancing rigidity with access. And this type of model really teaches us that the law is what the judge said the law is, and I agree with them. So Indonesia represents an emergent system where constitutional review exists, but direct individual complaint access does not at all. So by comparing these three, we can actually see a full spectrum from established to developing systems, identify what lessons Indonesian can be able to adapt. So yeah, the comparison allows us to really understand not only what works in theory, but what can realistically be implemented within Indonesian legal and political context. So thank you very much, and I am looking forward to applying your feedbacks in my future research. And whatever you say, I may agree with you because I can sense that you are currently in Germany. So thank you very much.
Thank you very much, Thomas Kumara. This is interesting discuss about the role of the civil society organization, because as we know, in Indonesia, the civil society organization is already the pivotal role directly to the decision of the Constitutional Court in constitutional review cases. Many landmark decisions actually applied by the constitutional civil society organization. So I think from the comparison with other country, that the infringement of the constitutional right have to real by the person. So the role of the constitutional society, social organization should be not directly anymore, but by how to advocate the people in Indonesia. Okay, thank you very much. And we have reached the end of the first day of the 7th International Indonesian Constitutional Court International Symposium. Thank you very much for Thomas Sekumara, Tantu Lailam, Mary Christian Putri, and all other speaker, respondent, and all participants. Thank you very much. See you tomorrow. Assalamualaikum warahmatullahi wabarakatuh.
Let's give big applause to the chair, speakers, and also respondent for session 3. So, ladies and gentlemen, participant of 7 ICCIS, session 3 concludes day 1 of 7 ICCIS. And tomorrow we'll start second day of 7 ICCIS. Start from joining the Zoom virtual meeting on 8:30. Then we'll start the day 2 on 8:45. So, see you tomorrow. Have a nice day.